Kowalski, et cetera, et al. Versus Johns Hopkins All Children's Hospital. Starting with the plaintiffs, let's take appearances, please.
Greg Anderson on behalf of the plaintiffs.
Ethan Shapiro, Pat Crowles, Howard Hunter, David Hughes, and Dr. Amin on behalf of the defense. Good morning.
Good morning. Are we ready to talk about exhibits?
Yes, Judge, so I just wanted to clarify, so we filed a rather extensive list. That wasn't intended to, like, we have to deal with all these today. It was rather an attempt to say, instead of doing these daily sheets, why don't we just say everything that we're trying to get in? And so this is not everything, but it's a large part. So does that make sense?
And can I, for the couple of them that have a Y, can I go ahead and admit those?
Yes, Your Honor.
Yes, Your Honor, and just for a couple, just for the record, 3031 and 3035, we stipulated them over our previous objection and the court's previous indication there.
Okay. So the court will receive, Madam Clerk, you ready? Okay, the court will receive over the plaintiff's objection 3031, which looks like it's pages 1 to 39, and that's the complete, is that correct?
That's my understanding, Judge.
As well as 3035, pages 1 to 26, which is, my understanding is the complete, is that correct? 3035, it's 26 pages.
Yeah, 1 to 26.
Yes.
Now, also by agreement, by stipulation, the court's going to receive 3029, 3050, pages 1 to 16, 3055, pages 1 to 15, 3124, looks like, is that all of the agreements? So is that all the agreements?
That appears so.
Your Honor, I never even saw this last night. I went to bed before 11:15, and obviously we could have not gotten through 8 pages in any event. So,
Okay.
Well, Ms. Crowell, what's next?
Judge, I'm going to address one that needs to be in before we play the video deposition. That would be 31352. They say it's already in evidence, but we checked, and these are photos that were taken by Dr. Major, and they did put in some, but we didn't think this particular photo was in.
Madam
And it's the
Clerk,
one that's used on the video with the doctor.
Madam Clerk, is 3135-0002 in? So it is not in? Any objection to 3135-0002?
no, Your Honor.
Court receives into evidence 3135-0002.
Okay, thank you. And then the next one that we would want in. Oh, I thought I marked it, Judge. Give me 1 second, please. Thank you. 3233.
3233.
Mr. Shapiro is going to address this one, Judge. He's more familiar with the exhibit.
Your Honor, these are the WordPress blogs authored by Beata Kowalski.
We only put certain numbers.
Yeah, we're not admitting all 257 pages. We've selected just the pages of the blogs. Not some of them follow what people can comment online. We're not seeking to admit the comments, just the words of the Mrs. Kowalski.
Was this the exhibit that there was a disagreement on authenticity?
Yes.
Well, I did ask Mr. Kowalski during his direct examination whether his wife authored the WordPress blogs, and he said yes.
Doesn't have to be
There's
specific.
a deposition of Georgia Kimball, who set up this WordPress blog, and her testimony is all over the place. That she authored some of it, she doesn't know which part she authored, she doesn't know parts Beata authored. Jack was never involved. I think his testimony was he knows nothing about the blog, he'd never seen the blog.
The answer is you're gonna have to, with evidence, demonstrate the authenticity of whatever you're trying to get in.
Through, can I say it's deposition testimony to the court?
Well, it's gotta be sworn evidence of
Yeah,
deposition.
Yeah, we'll, I guess, we'll have to make the proper one Monday. Yeah, we do have the sworn deposition testimony of Ms. Kimball, and respectfully, it says something different than what the plaintiff says, but we'll have to make the proffer on Monday then. I understand.
It's just, I mean, I remember this one being, I recall plaintiffs saying that they were objecting to the authenticity, so that's been a well-known issue.
All right, we will put together a legal memorandum and give you page line citation. Your Honor.
Right, and you're gonna have to, since it looks like you're going for selected pages, I'm gonna need to see that those pages were, that you're gonna have to prove the authenticity of those. Because if it's somebody other than Maya Kowalski or Beata Kowalski or Jack Kowalski, or conceivably possibly Kyle Kowalski, then you've got a hearsay problem with probably no exception.
I understand, and the inverse, I assume would be true, that if we could show that it was one of the four, it would be received as a statement. I understand, Your Honor, we'll put together the testimony.
If it's authentic and you can show that it's, you know, a statement against interest by, you know, party, then certainly that might be a different story. What's next?
Okay, moving on, Judge, we'll go to page 1, the 30191 to 14. The J. Hatch Interdisciplinary Clinic Practice Manual Medical Legal Policy, Images and Recordings. Their objective is unfair surprise. This was listed on our exhibit list of 9-1. It was also produced to them on 9-3. They never
Of
filed an
which year?
objection. And it was
Of what year?
of 2023.
Okay, so after the discovery cutoff date,
It was also produced, they sent us a notice to produce a trial. And that's DIN number, I wrote it down, I lost the DIN number. DIN number 3311. They asked us to produce at trial policies and procedures regarding the preservation and retention of videos, photographs, and electronic communications. So, I don't know how they're gonna say, surprise, Judge. It was produced pursuant to their request. It was also listed on our exhibit list, and when they filed all their objections to our exhibit list, they did not object to that one. They filed their objections on September 8th, after we filed our list on September 1st. So, I don't understand how they're surprised.
It was never produced to us. This is the first time that we've seen it. It may have been mentioned on an exhibit list. At DIN 485, going way back to September 30th, 2019, we sent a request specifically for any policies, procedures, etc., concerning the video surveillance of patients. And in their response, again at DIN 485, we were told none. So we've operated for 4 years on the premise that this does not exist. And to say that they produced it at trial when the first time they raised it or even show us a copy is last night, it's not bait stamped. It's an unfair surprise, and we were unable to use it in our case.
Judge, that's just factually incorrect. It was produced on September 3rd when we produced all of our
September
exhibits.
3rd, 2023.
That's correct, sir.
And the
But it's not-
document request for this issue, specifically number 4. Where did it go?
The response is at 485.
Yeah, okay, DIN 485, which is November 30th, 2019, so some, what, four years before?
Judge, it wasn't located until they did their notice to produce at trial in August. And
No, too late. I mean,
They
Look, if you had a 2019 request with a response of none, and then on the eve of trial saying, oh, here it is, that's too late. What's next?
Um, 3023, I'm confused by their comment. I don't recall withdrawing the Arnold Palmer admission at 4916. I don't believe that's,
I think what you said was that we discuss it later.
oh, that's right, thank you. That's right, because we're gonna have the testimony of Dr. Alexander about the issue I think they're raising a problem about. Okay. 3030.
Well, are we dealing with 3023 at this point?
No, sir. I think you said you needed predicate laid for the history, and that would be through the testimony of Dr. Alexander.
Thank you. What's next?
3030.
What is this?
This is Dr. Hannah's ketamine standing orders.
For Maya Kowalski, or just like a form that he uses in his office?
This is the form that he uses in his office regarding ketamine.
It's an undated form. It's not signed by the Kowalskis. There's no evidence is ever presented to the Kowalskis. There's no evidence if it was created 2016 or 2015 when he was treating this patient or afterwards. So we object to relevance, authenticity, hearsay.
Was
Wow.
this form used with Maya Kowalski?
Not that we're aware.
Yeah, I mean, these are the standing orders that were in effect at the time.
We have one person argue.
These are the standing orders that were in fact, this was produced to us through Dr. Hannah's office, Judge, when we subpoenaed the records.
Well, I understand it certainly is a hearsay document, but let's talk about if it was used with Maya Kowalski, I can see the relevance, but if it's just here's a form in his office without any connection with the Kowalski family, then why is this coming in?
Well, it's a standing order and it was used with the Kowalskis.
Well, when you say it's a standing order, it's not a standing order in the Kowalski case. It's a form that he uses in his office.
For ketamine patients.
But, and again, I go back to, did he use it in the Kowalski file?
Yes, that's my understanding.
So you will have this form annotated with Dr. Is it Hannah's handwritten notes with respect to Maya Kowalski, right?
Let's revisit it, Judge.
Are we all here?
No, sir. Two missing. Accident on the interstate.
I know
41
that.
blocked up.
Okay, but is there somebody out there waiting for him?
You're one.
Great, thank you.
Judge, we'll revisit this with Dr. Hannah.
Okay, but look, if Dr. Hannah's records has that form filled out in the Maya Kowalski, that's one thing. But if it is just a piece of paper in his office, then no.
I understand, Judge, but if it's a form that was in the file when we said, give us your records regarding Maya Kowalski, even if it's not filled out. If it was part of the record he produced in response to a subpoena for your records regarding Maya Kowalski.
If it's filled out with Maya Kowalski's information, then I think it's materially different than a blank form that's used in his office.
All right, Judge.
What's next?
3044.
3044.
And 3045 are going to be similar conversations, I'm assuming.
3044, pages 1 to 3.
So this is Dr. Sally Smith's preliminary medical evaluation report of 10/13/16.
And where does this reside?
Attached to the shelter petition, Your Honor.
Is this in the Johns Hopkins All Children's Hospital medical records?
No, Your Honor.
No.
Then no, it's not coming in.
Judge, to be clear, we listed it because we wanted to make sure our understanding was that Chapter 39 immunity also applied to this report by Dr. Sally Smith.
If this report went to the dependency court and was not part of the medical records, then, unless there's some explanation, it's Chapter 39
Okay,
immunity.
all right, so then the next
Well,
one,
if I may, to be clear, I think that's kind of shot across the bow and a suggestion that we're not going to be able to cross-examine her on her report. We understand it's not evidence, but we'll still be able to explore this with her if they call her in their case.
Well, I understood exactly that was the reason, but the reality is, right now, we're talking about whether that document is admissible.
Understood.
Whether you can use it to refresh a recollection or some other purpose, that's a different conversation.
Yes, sir. Thank you.
3045.
Yes, go ahead.
I'm sorry, I'm waiting for the objection. 3045.
3045.
Also, here, just rank hearsay, I think it's 45 or 53 pages.
This is her report that was used in the dependency
Yes,
action?
This is the report that is not part of the electronic medical records, but was put in the hospital paper chart, if you will, but not in electronic medical records, so that everybody could access it. This is the one that I believe Dr. Criticized heavily the hospital for having this in the hospital chart.
Yeah, I'm a little, well,
And in fact,
does she make diagnoses in this report?
Yes.
Can you pull that area up?
It's at the very end.
You go to the last couple, well, maybe 45.
Before that. Go back up before.
There's, yeah.
Here it is, yeah. Starts here, diagnosis continued. 42, 43.
Your Honor, can Mr. Hunter address this? He's more familiar with the document.
What's on the next page?
Before diagnosis.
No, I'm still, back.
Go back to those.
Mr. Whitney.
Your Honor, first, what they pointed to there is not a diagnosis. It's speculation with no foundation, no predicate, based on rank hearsay. If you look at the previous page, she never reached a diagnosis. She made an assertion that there's extensive evidence to support, but she never actually reaches a diagnosis. Then she goes on to complex regional pain syndrome, which she has no expertise in, admittedly. The hospital's noted that, DCF's noted that, and she attempts to refute the diagnosis of CRPS. This was not in the hospital medical record, not produced to us, and although there's this assertion that it was part of the paper chart, there were other paper reports, such as that of Dr. Lewis, that were scanned into the hospital medical record. This was never done. This was never produced to us in that fashion. It was specifically used in the Chapter 39 proceeding, and there is no diagnosis.
We've got the chapter, the DCF statement that she does not have background training experience, or somewhere.
I'm a little confused. Help me out, defense. For years, you've been wanting me to not talk about the dependency action, and now you're asking for the chief prosecutor's report to be put into evidence in the dependency action. So I'm unclear as to whether you're now asking this court to open up the dependency action.
No, sir, we're not. If I may be heard.
I will allow it.
This goes to a fundamental problem of contradiction in this case. We are being sued for vicarious liability for the conduct of Sally Smith on a parent agency basis. We are defending that allegation on two grounds. One is that she's not our parent agent and never has been. And that we have no vicarious liability for her. But in the alternative, that what she did was appropriate and within the standard of care.
But you would agree with me that this report has nothing to do with her treatment or lack of treatment of Maya Kowalski.
I would agree with you, Your Honor, that it doesn't have to do with the treatment of Maya Kowalski. However, that's our position. That's not the position of the plaintiffs. What we have heard from the plaintiff's expert, Dr. Newberger, as well as others, is a criticism of this report, of Dr. Smith's conduct, of her investigation, and of her alleged involvement as a result of what she found in this in Maya Kowalski's treatment. It's all wrapped up together. Now, this report was prepared, make no mistake about it, I want to be very clear about this. As far as we are concerned, this report was prepared in the course and scope of Dr. Sally Smith's role as the medical director of the child protection team for Pinellas County. We believe that this report was prepared as a result and part and parcel of the child abuse investigation, and that she, as well as we, are entitled to Chapter 39 immunity with respect to it. But if the plaintiffs are going to criticize her care, or her consultation, or her involvement, and attempt to hold us vicariously liable, therefore, based in part on this, we are entitled to introduce it. It was in the custody and it was in the custody of all children's, in the scanned paper documents portion of our records, not the legal medical record, just like Dr. Lewis's report.
Can I ask a dumb question? What's the hearsay exception that would allow this in?
This is a business record that was created by Sally Smith in the course and scope of her ordinary business practice.
For
The Chapter 39 investigation.
this document is hearsay. This document was prepared for the dependency action which the defense has been seeking to continue to have it excluded. This document, in addition to being hearsay with no hearsay exception to which it would apply, also, even if it did, has a substantial 403 problem. This is not diagnosis or treatment of Maya Kowalski. So there is nothing that this report can do to salvage itself from a hearsay problem. Not alone the Chapter 39 immunity, which also exists, and I've been hopefully very consistent on. At the end of the day, what the jury is going to be instructed has to do with medical malpractice. And there is evidence that Sally Smith went well beyond her role, taking off the hat of child abuse investigator and went into the role of treating physician. And that is the conduct to which All Children's Hospital, or Johns Hopkins All Children's Hospital, depending on the apparent agency issue, may or may not be responsible for, not the role of her as the child abuse investigator. So this document is not coming in. 3045 is not coming in.
Judge, let me just note two things, if I could, for the record. One is that we take issue with the court's comments regarding her participation in care and treatment. The other is that we may be placed, as a result of your ruling, in a position of both defending conduct and having this document, as well as other activities on her part, used as both a shield and sword by the plaintiff. And we will have to revisit this when Dr. Smith appears to testify. And the foundation we may again attempt to lay the foundation. I'm just telling Your Honor, this contradiction goes to the heart of the problem we've had with the entire case as far as Chapter 39 is concerned. Thank you.
What's next?
3046. It's court removal in 2018 of Maya Kowalski.
Our objection here is that this insinuates to the jury that this was a medical decision made by the Kowalski family in the absence of the material context, which is that the hospital argued strongly in the dependency proceeding that she should not be allowed to receive ketamine anymore. And so to put this document in and suggest that the Kowalskis realized that ketamine was no longer helpful when they were under, in their minds, a court order prohibiting them from using ketamine would be prejudicial. So we object on 403, we object on Chapter 39 involvement, we object on relevance to this document.
Judge, this is 2018. This is long after the dependency court has been dismissed. They went in and removed the report. It's a medical record.
I'm going to allow it, and there was also testimony and questions as to whether the port was removed at Johns Hopkins All Children's Hospital in 2016. So this would perhaps answer that issue. So 2046 pages, is it 1 through 6?
It is.
Will be received.
And we would like some instruction on whether we need to approach before we cross-examine. If when they bring this up, whoever they bring this up through, when we cross-examine on the reasons underlying this port removal, do we need to approach or can we explore those issues?
Well, I don't know what you mean by explore those issues. Haven't we previously talked about that the Kowalski family's understanding was allowed to come in as to whether ketamine treatment was allowed to come in the future or allowed to occur in the future?
I'm sorry, I didn't recall that. Thank you.
I mean, am I misremembering that? Because I thought we had a discussion before the trial started as to the meaning of the legal effect of the continued vitality of the dependencies court order after the shelter proceeding had been dismissed. And I think I wasn't going to go there, but I think we did have a discussion that the Kowalski family's understanding was, that goes to their state of mind.
Yes, I think we tried to tread a very thin line with Mr. Kowalski on the stand, and we didn't specifically mention the position taken by Johns Hopkins to prohibit ketamine. The testimony was rather that they were they had this general fear and concern that if they went back to ketamine, the process might repeat. That was kind of the nature of the testimony. We didn't go perhaps as far as we were allowed to go, which is the reason that this was done, the reason that they weren't doing this, because there's this court order entered based on Johns Hopkins' argument, and we would like to be able to go there.
But am I misremembering that conversation?
No, Judge, you're not, but here's the essential thing that the plaintiffs keep trying to do. They just said twice that the ketamine infusion wasn't allowed because of Johns Hopkins, when we all know it was because of a court order, and they just again said the ketamine wasn't allowed because Johns Hopkins' recommendation to the court. They keep trying to deviate from this court's rulings with respect to that.
Well, obviously, there's no jury in front of us right this second. The issue that Mr. Whitney wanted to do is, does he need to come forward? I don't know what issues you're going to attempt to address with respect to this document.
Judge, it's a medical procedure she underwent in 2018. It's relevant. She
Yeah.
didn't
And
have
I've-
a relapse afterwards. It's relevant for, it's being a medical record for Maya Kowalski.
And I think I've already said that I'm letting it in.
Okay, sorry.
But I was going to Mr. Whitney's, he wants to approach, and I don't understand what we would be approaching on.
Understood. We'll wait till the time that happens.
But in this case, better safe than sorry. So
Yeah,
if you think it's going to be close, please come forward.
I'll push.
never approached so much in my life, Judge, but we're trying to abide by that.
I feel like a jack in the box here.
Yes. All right, moving on, Judge. 3051. This is the report by Jack Kowalski regarding the fact that his wife is missing, the gun is missing.
Huh?
This is the report by Jack Kowalski, I believe it's the day before the suicide, or the day of the suicide. I believe this is relevant to their irresistible impulse argument, Judge.
Didn't Mr. Kowalski already testify to this? What, we normally don't put in police reports. So, I think there's already testimony on this issue, and it's a hearsay document, so let's not put it in.
All right, Judge, the next one, I'm not understanding their objection. It's 3054, they say objection, page 609. Maybe that's a typo?
Which one? What are we on again?
Can you put up 3054, please?
I don't think there's a page 609.
That's a mistake, obviously.
Yeah, so they could identify which page.
Well, there's a Bates number down at the bottom.
Oh, maybe that's it. Thank you, Judge.
All right. Paralegal's way ahead of all of us.
Yeah, just too clever for us. So 609, can you go to Bates 609?
Page 10, I think.
On this document, on the right, you see Bates number.
Page 10 on the exhibit.
Can you go to 609, please? It's probably, is it the toll page that you're objecting to?
Well, is this the page you're
It looks to be, and I'm just reviewing it now for the first time, but there's a whole lot of hearsay within that first entry.
Well, what date are we talking about first?
This is September 25th, 2020.
She's having trouble climbing the stairs.
Judge, it goes to her condition as of September 2020. She's climbing the stairs, for one.
I mean, fair, that could be a medical condition, perhaps. It's not for medical diagnosis or treatment. The problem is, I mean, sentences like, RN stated student had told counselor it was her asthma. RN also discussed it could be related to her not weighing enough and could make the stairs very taxing. And so it appears to me that it's not clear whether Counselor Wolf or the RN completed this form at first glance. Either way, it'd be one or the other reporting hearsay of the other in this document.
Triple action.
To the extent there are comments by the dad, they would be admissions. And RN was clearly a medical personnel.
It begins with Counselor Wolf called and reported. So things related to Counselor Wolf, who I don't believe has in medical training. I don't know that. I don't know who she is. He is, but foundation predicate, and then there can't be statements to the counselor cannot be for a purpose of medical diagnosis or treatment. So it's not subject to an exception. And I'll point out that they had leave of court to take depositions of counselors, teachers, and I don't believe they took the deposition of this individual or asked about this document.
How are we going to use this document?
Well, I don't know, sorry, Judge, I don't know that we're using it with a particular witness, but there are statements in here by the dad which would be admissions.
That she doesn't weigh a lot? That she's able to take the stairs? I mean, I'm trying to understand how this is going to be.
It puts in context where how she's doing as of October of 2020.
Here's, well, let me just tell you my view. I don't really see how this document helps or hurts anybody, but I do have concerns about statements from where it says RN, and I'm not sure that means registered nurse in this context. I really don't. And because we all understand, or I don't think we should say that, but I would suppose that a lot of the school nurses are not RNs. And I think RN could be the identity of a person.
I understand the court's concern. I would say I think they are generally aren't trained to give meds, but
well, but it's implying like she has some sort of medical training and is giving advice and talking about conditions which I suspect she has no understanding of.
I understand.
So I just think it could be misleading. That's my concern. But that being said, it's consistent with everything that the plaintiffs have been saying. So
Okay, Judge.
I until I know more.
All right, well, can we put a pin in it, so to speak, Judge? There's apparently an issue with something that counsel wants to use with the witness today. Can we switch to that issue? And we'll
On this document?
No, sir. It's separate and apart. If we
Okay.
could switch gears so that we can address the witness issue.
If you can put up I just have a diagram of who's who in this trial that I wanted to show to Detective Graham. I showed it to plaintiff's counsel. I don't know if there's an objection. It's just a trial illustration. I don't know what the objection would be. Obviously, I'm not putting this into evidence. I don't know, maybe there's not an objection.
Wait a second. To Detective Graham, how are you going to,
Because,
did Detective Graham talk to each and every one of these people?
no, I'm just gonna, I want to make sure the jury understands Detective Graham does not work for All Children. She's not one of the employees.
No.
I can't,
I mean,
I think it's important, well, I plan on bringing an illustration like this to be able to show as witnesses come in front of the jury who works for who, because there's mass confusion.
you're asking me to use this with Detective Graham to show to the jury.
Well, the same way as
And
if I had.
that answer is no. Detective Graham, you just said, didn't talk to all these people, so why are we showing pictures of all these people to Detective Graham?
Well, I was going to show it to the jury just as if I had a board, but I'll just print one out then, and I guess I could bring it that way.
I guess I'm fundamentally misunderstanding. You want to show all of these pictures to the jury during your conversation with Detective Graham when Detective Graham didn't talk to these people.
Right, just so I
So,
could, okay.
why?
Because I wanted to make sure the jury understood that Detective Graham is not one of the people on the All Children's team.
So you're going to ask if she was a member of the Sarasota County Sheriff's Office, and you think you need a picture to say that she's not part of Johns Hopkins All Children's?
I'll put this into a bigger trial illustration, and we'll use it at a different time.
I mean,
There's rampant confusion with this jury about who works for who and at what time people work for people. And what I was trying to build as people come to testify to make sure the jury understands these are the All Children's people, these are the Safe Children's Coalition people, these are the DCF people, so we have a running tally.
perhaps that's part of your closing argument, perhaps, but I don't see why you start putting up pictures of other people that Detective Graham didn't talk to.
Okay, I understand that.
Sure. You go here, Joe.
Okay, let's give them a couple minutes. Did they just get here?
Yes, sure.
I'm going to briefly excuse myself because I think Detective Graham is here per Mr. Anderson's request that we try to get her on earlier. I think the plan, just so you know, is to play a video while I can talk to her about what's permissible and not permissible for her to talk about.
Okay, but apparently a couple of the jurors just got here because of the crash that was on the interstate, so I want to give them a few minutes. So see if they'll be ready to go in about 5 to 10 minutes, or do they need more time?
He's driving the last two over.
Okay, so they're not physically in the building yet. So it's still going to be another 10 minutes or so.
Your Honor, before Mr. Shapiro excuses himself, I think we need to address the motion that we filed yesterday evening. I think Mr. Anderson's going to take it.
Okay, but understand, if you don't file something after like 5 o'clock, the clerk won't docket it until probably lunchtime today, so
I have a copy for Your Honor.
thank you.
That approach.
Yes. Didn't we already address this?
Twice, Your Honor.
My recollection was there was a criminal investigation proceeding.
Yes, Your Honor.
There was one filed on October 8th. However, the recordings and the actual clips that they seek to introduce have nothing to do with a criminal investigation. They have to do with pursuing on behalf of Sally Smith and the CPT team some information that they will need. So the clips that they want to show are, did you consider leaving your wife? Things like that. They're not going to anything that 934.04 to .09 requires, and the purpose of such interception is to obtain evidence of a criminal act.
Well, let me stop you.
Yes, sir.
My recollection was we were going to deal with each specific statement differently, But generally speaking, there was a criminal investigation into Beata Kowalski and potentially Jack Kowalski at that particular time. And therefore, and I've already ruled on it and I'm not changing my mind on it, is Florida law would allow the detective to record unilaterally that investigation.
And if it was indeed a criminal investigation and that is the basis, then there was a requirement that the witness state that she had a reasonable suspicion, which I asked in deposition, and she said she had not formed any, or that she had probable cause, which I asked in the deposition, and she said she did not have any. And so if it was a criminal investigation, she had an obligation under these circumstances to Mirandize or otherwise allow representation of counsel, which she also admitted in her deposition that she knew the Kowalskis had. So in terms of the violation of fundamental rights here, we've got the 4th, 5th, and 6th that, by her own admission, have been violated, and you've got the problem here of her recording this and taking, quote, evidence, testimony, without even complying with 934.03. Our point is, it's either one thing or another. If it's a criminal investigation, she should have been looking for probable cause, reasonable suspicion, and she should have been Mirandizing and respecting right to counsel. If it wasn't an investigation, then 934.04 through .09 would not allow her to take such information without addressing that fact with the Kowalskis. It's got to be one or the other, and I've got her deposition testimony to this effect.
I maintain my prior ruling on the issue. So are there what specific clips are you seeking to use, Mr.
I can, if you want to hear them all, yeah.
Well,
Whatever's easier for Your Honor, there's about probably 12 total that each run somewhere between 15 seconds. So whatever you prefer, Your Honor. They're all relating to statements about staying in the
while
hospital.
we're waiting for the jury, let's...
Okay, so I guess in order, if you want to play number 1.
I mean, when we were in a meeting with the doctors one day, and Beata wanted to take Maya out, sign her out, and I said, hold on, time out. And this wasn't in the, wasn't written down, which I was kind of mad about, but I asked the doctors, I said, what's the time frame you talking about? And they explained. I said, that's doable. And was my wife happy with me, what I said? No, absolutely not.
Okay.
So you have to, there's times I'm going to go the other way.
Okay. And thank you for sharing that.
I don't know why they didn't write that down.
So that one we would seek to admit as obviously goes with the false imprisonment.
Does not go to criminal intent, and also hearsay. It's fundamentally based on hearsay. And simply because it's a criminal investigation, hearsay rules still apply. And there's no exception that I've seen. Not to what he said, what Jack said, but what he was told.
That will be allowed. Are we identifying this? Is there a specific A, B, C, D, E?
I just have it as clip 1. That's the way I've identified it, however you prefer.
Well, is this coming into
Oh,
evidence?
yes, we would seek to admit it into evidence, yes. We'll have that as clip A.
Of what number are we talking about?
The recordings are 3120. Sorry, 2130.
3120.
The recordings are 3121.
3121, clip A is okay. What's B?
I'll do clip, if you'll play clip number 4, that'll be B.
And we have to be absolutely clear, since we're now specifying which one they are, that we're not changing them.
Yeah, can you give me 1 second,
Judge Earl here.
Tell them about 10 minutes.
All right, yes, 3121A. That was.
Yeah, so we'll do 3121B, which is clip 4.
My bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. this is not, I mean, also what it taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here and looking.
Again, we would seek to admit it regarding his consent to treatment on the issues of false imprisonment, even as of November 17th, admission by a party opponent.
Again, Your Honor, relevancy materiality, and again, it does not show any criminal intent, it does not show a crime was committed, and hearsay, of course, although there's maybe an exception to it. This one would require foundation and predicate from Jack Kowalski.
Overruled. What is C of the charge?
C would be clip 7, please.
But it's just your wife's behavior is very concerning to me.
Sure. And it's getting worse right now. Just, she don't want to cooperate.
Addition?
Yeah, 934, and again, this requires some type of qualification that it was for a criminal act as opposed to just some sort of, I don't even know if you call it bad act, what it is. But then it's relevance.
Well, again, the 934 objection, chapter 934, is overruled because there is an exception in the statute that would allow for this. Now, if this were a criminal prosecution against Jack Kowalski, maybe it's a different story, but that's not what this civil trial is. So the court will overrule those objections and allow C to come in as well. So A, B, and C are in so far.
The next one, Clay, would be clip 12.
Because I know Mom talked to her once, and that was supervised. And I guess she got shut down many times because she was falling off the track.
She could.
And
Why can't
then
Mom?
she told me what she said. I said, you can't do that. Don't talk about medical stuff. Why are you talking about the lawyer? Why are you going to...
Why can't she control? If her daughter is her main priority and why can't she follow the rules and do what she's being told?
Exactly.
Anything else, Mr. Anderson?
Again, as of this particular one, 403, in addition to the others, 403 and relevance.
Overruled. What's the next one?
The next one would be clip 11, please.
Was that last one D?
That last one was D, yes. This one will mark as Exhibit D, clip 11, please.
But, like you're saying with all this recently of calling and demanding, I'm appalled over it. I'll be the first one to admit. It's the last thing you want to do during this. Number one thing is to focus on her getting better. Don't cause waves. Is she causing waves with me too with it? Yes.
Tell me about that.
I don't agree with what she's doing, calling and questioning.
And how does that go at home when you tell her, knock it off, this is not what's best for Maya?
That's right.
Do you tell your wife when you go home that Maya is progressing and doing well? What's her response? Or aren't you telling her?
I tell her, but I don't talk to her about, I'm not trying to talk medical to her. I don't want her because then she might get on the phone and say, why aren't they doing this? You know how many times she asked me, why don't you ask them about this? Ask the doctor this, ask the doctor that. It's like, no. She's your daughter, but she's under state custody right now. So whatever happens, happens. I says, don't tell them what to do. Does that go over well? No.
Chapter 39, the argument between Beata and Jack was excluded on that basis. This goes to that at the same time, and as well as 403 and relevance to what crime is being attempted to be proven through this. But again, Judge, the problem we're gonna have is when you get into what's they're being talked about here, I have to cross-examine on this.
I am somewhat in agreement, but let me hear from Mr. Shapiro.
Sure.
Because I think this one really is a little bit different than those other clips.
Okay, the reason why I was offering it was because there's a lot of information that the jury's received about why calls had to be redirected, what was the discussion of the calls on supervised visitation, and this is an admission by a party opponent that he's acknowledging that the subject matter that Mrs. Kowalski was bringing up on the supervised calls was in a matter that was adverse to the child.
Okay, but we also have a discussion about what a husband and wife are talking about, and there's other issues that are included in that clip. So I'm going to keep E out. What's the next one?
Okay. Let me just make a note so I don't play that one, Your Honor. I would go to clip 8, please, that I'll mark as F.
Let me ask you, if Maya was released tomorrow and you guys got that child back, would your wife want to make an appointment with Dr. Hannah or doctor to take him? Would she?
It's a good possibility.
And would that surprise you? If she thought, oh, we need, she's been without pain meds, we need to get her down to Dr. Hannah for a booster.
Possibility. Probably do something like that.
Well, as to that one, and I do want to assert the husband-wife privilege to the extent that any of this goes to communications. I'm not sure that one does. But again, when we're talking about in Chapter 39, what is the relevance here of whether or not she's going to take the child back to Dr. Hannah? Yeah, it is speculative by Jack Kowalski. And we, again, do not see how it is relevant to any of the issues that they're, I guess, using this for. And so under Chapter 39, plaintiffs move for the court to keep this very narrow.
And Mr. Shapiro, I mean, it is asking for a forecast of future conduct.
Yes, it goes to the direct allegation of the concerns of the hospital that Mrs. Kowalski, the Kowalskis were planning on, if they were going to go to pursue what the hospital's defense is, which is unnecessary and very dangerous treatment, it goes to the allegations of Munchausen by proxy. And so this is highly relevant as a statement from a party opponent telling, admitting that one of the things that the Kowalskis were going to do, which validates the concerns at All Children's, that they were going to take Maya from the hospital to Dr. Hannah, and it shows their intent in that regard.
Okay, but fundamentally, the discussion about the future conduct really is a Chapter 39 issue. It's not a criminal investigation issue at that point, because crime, we're talking about conduct that's already occurred, not, you don't arrest people about what's going to happen in the future. We tend to not do that. So, one, I think it's speculation.
Just one last basis would be the state of mind. I apologize.
The conduct of, or what Beata Kowalski believed, and I think it's very clear I don't think I'm going on a limb on this, is she felt that the Johns Hopkins treatment course was wrong, and that the best care for her child would be to have these ketamine treatments. That is, parents are allowed to disagree with the course of treatment, and that's why the hospital has to honor the against medical advice. If the concern is the hospital is saying, well, what the mom might be doing, that goes straight into Chapter 39. And since it's a future event, it's really not part of a crime investigation. So F as in Foxtrot is out as well. What's next?
Clip 9, which would be G, please.
No, I thought you were going to answer the question. If Maya was released from here and she was going to be brought back home, if I would have had my wife move out.
That's my next question.
That would be absolutely in a heartbeat.
Objection, this is speculative, future events, go straight to chapter 39, and questionable relevancy given this, but this is again towards the future events that may or may not happen, if your wife, etc. And so, then there's also, I guess, a communication problem with husband and wife privilege.
There has been testimony about whether there was a plan to have her move out for a legal reason. So that has already been in there, so I don't think we can say it's not relevant.
But still speculative as to a future event, what would happen if? And remember, Judge, throughout all this, even by the DCF.
Well, but it's
court
him
order-
as opposed to Beata.
Say again?
It's what Jack Kowalski's going to do and not what Beata Kowalski's going to do.
Based on what the if of what Beata Kowalski would do, then it would be on what Jack would do if Beata Kowalski would do. And the Kowalskis, by the way, retain their minute wills, not appropriate to this point.
On this one, I am going to admit it is relevant and it's distinguishable from F as in Foxtrot on what I just indicated. So the court will receive G as in golf.
3 more, Your Honor. The next one would be clip 3, which will mark for identification as H.
I don't see a child in pain. I don't see it.
Yeah. Well,
I see a child who's probably trying to appease her parents or parents.
do you honestly think she can't walk because
I think there's a psychological component,
I would
and I
agree?
think
It goes to the state of mind of Mr. Kowalski and his observations that there's a psychological component to Maya's pain.
This is directly chapter 39, and this is also the police officer offering her medical acumen, or lack thereof.
I agree with that one. So H as in hotel will not come in. What's next?
What we'll mark as I would be clip 6.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she was instantly in
I've
pain.
heard that many times.
There's no other explanation
I-
for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work,
And all of a sudden she's back.
there'll be changes, yes.
So you're at home, your guys are doing well, they're playing.
No complaints about pain.
No complaints about
But then
that.
when Mom gets home,
She's in
maybe-
pain.
This is all fundamentally based on hearsay. This is a predicate laid for Jack Kowalski based on pure hearsay. And again, we're leading into chapter 39, and we are, again, speculating on what would happen. There is the part about what Jack saw when Beata came home. But again, what we're trying to, I don't understand what that's relevant to in light of what the predicate of the question was.
Okay, the court will admit I as in India. Obviously, there's Jack Kowalski's direct observations are highly relevant.
Can we edit out the predicate, the hearsay predicate?
Well, let me hear it again.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she was instantly in pain.
I've heard that many times.
There's no other explanation
I-
for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work,
and all of a sudden she's bad?
There'll be changes, yes.
So you're at home, your guys are doing well, playing,
No complaints about pain.
No complaints
but
about
then when
pain.
mom gets home,
she's in
maybe-
pain.
So the part where I heard from the hospital and then
Hold on a second. Okay, I agree. So we'll start it with the word when. So it's that first few words.
Okay, Clay will need a couple minutes to edit that, but I'll,
The word when is where we're going to start it.
Is that when the detective is talking?
yes.
Yes.
Last one, Your Honor.
And hang on, Judge. Maybe we need to listen to it one more time because the substance of the hearsay, I thought, came after the when. Simply by taking out the source of it does not relieve it from being hearsay.
Play it one more time, but I'm pretty sure I'm going to allow it starting with when.
I was told here at the hospital upon her admission, and maybe some of this will shine a light on at home too. When nobody else was in the room but Maya and the staff, she acted completely normal. When mom would walk in the room, she was instantly in pain.
I've heard that many times.
There's no other explanation
But
for that.
Yeah, I noticed it too with myself being home, and then mom comes home from work.
And all of a sudden she's bad.
There'll be changes, yes.
So you're at home, your guys are doing well, playing.
No complaints about pain.
No complaints
but
about
then
pain.
when mom gets home,
She's in
maybe-
pain.
It needs to go from the end of that description, because what that description is about is repeated back by Jack. And so that's, I understand the court's ruling on that. But that predicate leading up to it, to the very, very end there, when Jack starts in saying, and to put it, it's put into context by the latter part of it.
We're going to start playing it with the word when. And you said the last one coming?
Last one is clip 15, which will mark for identification as J.
So when you heard this term, you saw it. Did anybody explain to you what it was?
I looked it up
Where did you look it up at?
on my phone.
WebMD? Or some
I
other?
just typed in,
And what do you recall it saying about Munchausen by proxy?
for what it said, it was almost textbook of what we went through.
Mom's in the medical field.
Mom's the
Mom's overwhelmed. Mom's demanding.
Yes. And it's like, one of these, Yeah, it was concerning.
This is based completely on what he read at the time, which was hearsay. So he's repeating back something he said at the time. And so first thing we have is hearsay within hearsay. Yes, and additionally, now we're getting into chapter 39, diagnoses.
Oh, Mr. Anderson, let me hear from Mr. Shapiro because I think I'm in your camp on this one.
Yeah, so on the first issue, it goes to Mr. Flosky's state of mind on this, if you want me to address the second issue on chapter 39.
I think you need to address the 39 issues.
Okay, because again, the issue of Munchausen by proxy, the plaintiffs have put directly into evidence that that was a misdiagnosis. They've called Dr. Newberger on this topic. They're complaining that the diagnosis codes were wrong, and that's why we refused to transfer. And here we have the state of mind of Mr. Kowalski acknowledging that based on his understanding of it, there is a prima facie case that it's a concern that he had as well. It goes to his state of mind at that time, during the hospitalization, at the exact time they were trying to transfer Maya.
J as Juliet is out. So in 3121, I have let in A as in Alpha, B as in Bravo, C as in Charlie, D as in Delta, G as in Golf, I as in India. And I've excluded E as in Echo, F as in Foxtrot, H as in Hotel, J as in Juliet. With respect to I, obviously it's going to be reduced from the totality of the clip. So defendants, let's make sure when you are providing these clips that you provide those that are excluded on a different media so that when these clips go back to the jury, or so that they can go back to the jury. I see you have that question in your mind, Mr. Hunter, but I think your paralegals understand exactly what I'm saying.
I got it.
Okay.
Judge, I have one more. I'd like the court to reconsider just for a moment B, which is where he says we'll keep her here. At that point, at the time of this recording, there was a shelter order in place, so there was no real relevance to whether he wanted to keep her there or not. This was not during the period of when, the 7th through the 13th.
My bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, also what would have taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm receptive of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here and looking.
Reconsideration denied. Obviously, that goes. There's a criminal investigation into some sort of child neglect, child abuse. That type of question is directly relevant there to that criminal investigation. So it survives a 934 analysis, and once I get past the 934 analysis, it's a statement against interest. So, and I don't see how that's a Chapter 39 issue, because we have a false imprisonment claim. So,
Judge, but this statement was made on November 17th. For it to be relevant in any way, it would have to be in the period from the 7th to the 13th, or 14th, when the order was issued. After the 13th or 14th, when this was done on the 17th, he had no choice whether to keep her there or not.
I am.
So it doesn't go, it's not relevant to what the point they want to put in, which is that during this period of time, from the 7th to the 13th, he said it would be fine to keep her there. If it was during that period of time, yeah, sure, it's relevant. But now we're after that. He's already in the shelter order time period. So what is it probative of? That after that, he still...
I've denied the motion for reconsideration. Let's move on. So B as in Bravo is in. Okay. What are we doing? Are we doing the detective first?
No, Judge, we're going to play a 55-minute video. And then, or a 45-minute one. We can do a 45-minute one if you prefer, given the time.
Yeah, maybe we'll do that, Your Honor. We'll play this.
Well, what's coming after that depot?
That'd be
Detective
Detective
Graham,
Graham.
who I'm going to meet with and make sure she knows which statements.
So I'm bringing in the jury for 45 minutes and then sending them back out?
Or, no, we'll be ready to call Detective Graham at that point.
Which deposition are we trying to play?
Well, whatever the court pleases. We have one that's 45 minutes. We have one that's 55 minutes.
I need to walk off the bench just before noon, and we're going to take.
Okay.
I'm going to take. When we bring the jury in, we're going to do a deposition. Then we'll take a break after that. Are you okay? Are you okay, Madam Court Reporter, if we go for up to 55 minutes, or do you need a break now?
No, I should be okay.
Well, that means she wants a break now. So.
The issue is I don't know which deposition they're going to play, and I understand we've only been provided Dr. Malik. We haven't been provided these depositions.
Okay.
Who's the 55-minute one?
We have provided you.
Just Ms. Krause.
The videos.
This morning.
Ms. Krause. Folks, to me. Who's the 55-minute one?
Dr. Revivo.
There you go.
We were never provided that clip, that video to review until I guess this morning. We just got it.
No, we don't have the video still.
We don't have the video. We've never had a chance to review it.
Okay.
But they
We thought they
provided
had
their
One person.
they provided their cross designations.
No.
Have they had a chance to verify the clip?
Okay. Judge, I was
That
unaware.
answer seems to be no.
I was unaware that was the case. Which ones have you viewed?
Dr. Malik is the only one we've received a complete video of.
Well,
With enough time, not this morning, with enough time to see it.
Well, if you prefer we do Malik, we can do that, but then Mr. Anderson's gonna be here through lunch while we do that one, and we'll put on Detective Graham after lunch, so it's your, whatever you prefer.
The goal was to try to get.
I don't care what the goal is. I've got a jury waiting. You know my time constraint. Make a decision. Do you want Dr. Malik, or do you want to go with a deposition that you haven't had a chance to review? Or force them to call Graham now?
Yeah, I might be able to get her in 15 minutes, be able to put her on by 9:45.
Judge, if counsel's telling us that all of the objections, the court's rulings have been honored, and all of the, my cross is in there, then I will trust counsel that that's the case. As long, and it's for the purpose of getting Detective Graham on this morning.
I designated everything that's highlighted.
There we go. So we want the 55 or the 45 minute?
We'll do the shorter ones so that way you can get out of here.
Thank you, Ethan.
Okay, so we'll do the 45 minute. What we're going to do is we're going to take a 5-minute break. We're going to tell the jury we're taking a 5-minute break, and then as soon as we come back, they're coming in. So if they need to use the restroom or anything, have them do it now. 5 minutes.
please be seated. Is Mr. Shapiro going to be outside during this?
He is.
Okay, so we don't need to wait for him?
We do not, Your Honor. I do want to mention that the video does show records, but they're in evidence.
Are we confident that all of the...
It's the Lori Hospital records that are in evidence.
Okay.
Wondering also if we could give a brief just introduction from your own inform the witnesses about the time frame in which the doctor was involved. Would that be acceptable?
Yeah, I'm assuming someone's going to say it's on this date. The deposition's on this date.
Well, I had the deposition date, but I was talking about the treatment dates more.
It's in here.
It was Lurie Children's Hospital and 3 days at the hospital.
It's in there.
Something you feel comfortable saying.
Well, let's see what actually is said. I mean, if it's clear in the deposition, then I try not to insert myself at all if I can help from it. Anything else, or can I bring in this jury?
No, Your Honor, nothing else.
Let's bring in the jury.
This is the first video I recorded. Is there a place I can see the screen without having to move the world?
We're going to try. Okay, welcome. Please be seated. So, members of the jury, everyone made it through the interstate okay today? I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that correct? Correct. And that no one approached you about this case. Is that correct? Correct. And have you seen any media coverage about this case? Is that? I heard a correct and a no. So, did anyone see any media coverage? Let's try that one more time. It's Friday. Has anyone seen any media coverage of this case since we were last together? No. Thank you. Ms. Crowells, the next witness, please.
Yes, we're starting with a video deposition of Dr. Zachary Pitzenberger.
Is the lighting, you want it brighter, less bright? Okay, thank you.
Today's date is October 20th, 2021. Today's date is October 20th, 2021. We are on the record at 10:03 a.m. in the deposition of Zachary Pitzenberger.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Let's start off with having you state your name and your professional address for the record, please.
Zachary Pitzenberger, 225 East Chicago Avenue, Chicago, Illinois.
And where are you presently employed?
At Lurie Children's Hospital in Chicago.
And my understanding is you are a pediatric emergency room physician. Is that correct?
That's correct.
Can you please start off by giving me the benefit of your education and training, starting from where you graduated from undergraduate all the way through any residency and fellowship training that you have?
Sure. I did my undergraduate education at Bowling Green State University in Ohio. 4 years. My degree was in biology, and then went to medical school at University of Cincinnati, College of Medicine, and did a 4-year training there. After graduation from medical school, I did a residency in pediatrics at University of Colorado in Denver. And after completing that, I went to a fellowship in pediatric emergency medicine at Boston Children's Hospital in Boston. And then since I graduated there in 2013, I've been employed at Lurie Children's Hospital in Chicago.
Okay. And I understand the fellowship training you did, that was in pediatric emergency medicine?
That's correct.
That's Boston Children's Hospital. I believe that's affiliated with Harvard Medical School.
That's correct.
Okay, so it's safe to say you have some Harvard training?
Yes, you could say that.
Where was your fellowship, doctor?
At Boston Children's Hospital in Boston, Massachusetts.
Okay, and that was in what specialty?
Pediatric emergency medicine.
I also understand you were the chief fellow on your CV here. It says chief fellow, Harvard Medical School. What does that mean?
During the final year of my fellowship, I was in charge of several administrative tasks regarding the fellowship, like scheduling conferences and things like that.
Looking through your CV a little bit here, Doctor, I see that there's an invited lecture here entitled Child Abuse, Overcoming the Disbelief, where you were a speaker in 2016. Can you tell me a little bit about that?
That was a conference held by our transport team at the hospital, where they asked me to give a talk on child abuse. And it's in detecting it in the primary care setting as well as in emergency rooms and urgent cares. So just kind of looking for different signs and symptoms that could be indicative of a child abuse case. And I presented at that conference.
What did you review today, if anything, in connection with preparing for your deposition?
My note from the visit in 2016, or 15, sorry, 2015.
Okay. And that was a July 21, 2015 visit at Lurie Children's Hospital in Chicago?
That's correct.
Where were the services that you rendered in July 21 of 2015?
In the emergency department at Lurie Children's Hospital.
Okay. I also saw on your CV here that you have a publication, Pitsenbarger ZE, entitled Trends in Pediatric Visits to the Emergency Department for Psychiatric Illness in the Academy of Emergency Medicine for 2014. Can you tell me a little bit about that publication, please?
That was a research project I completed during fellowship in which we, using a national database, just looked to see what trends were happening with visits to the Emergency Department for Psychiatric Illness in children.
As part of your training as a pediatric emergency room physician, is part of your training consist of psychiatry?
We don't do any specific rotations in psychiatry, but we see many patients with psychiatric conditions who come in for those concerns and treat them while they're in the emergency department.
Okay. And so screening for potential psychiatric illness, is that something that is within your training and expertise as a emergency room physician?
Yes.
Okay. Are you familiar, after the patient left the emergency room and left your service, are you familiar with Maya Kowalski's course at Lurie Children's after your involvement?
I am not.
The date of arrival was what date?
July 21st, 2015.
Okay. And the patient, again, was Maya Kowalski, correct?
Correct.
Okay. And how did she arrive at the emergency department on July 21, 2015?
By ambulance, it appears.
Okay. And under the comment here, do you see where it says comment from Florida, severe pain, quote, myopathy, here for second opinion, joint pain, bone pain? Do you see that?
I do.
Okay. Who would have these chief complaints? How do those get entered into the chart?
They're entered during the triage process by a nurse when they first meet the patient.
Okay. And who would have been the source of that information in that comment, most likely?
Either the patient or the patient's parent or guardian.
And at the time, do you know how old Maya Kowalski was?
I believe later on in the note I see she was 9 years old.
And on this first page here, we have something that says here HPI. Does that stand for? Well, actually, let me ask it since there might be an objection. What is HPI?
So HPI stands for history of present illness.
Okay, and typically, who provides the information for an HPI?
The patient or the patient's caregivers.
Okay, so it's fair to say the information on the HPI here would have either come from Maya Kowalski or her mother, Beata Kowalski?
Correct.
Do you have any, at the time you're rendering this diagnosis, do you have any independent records to confirm or substantiate what's on this HPI?
I believe they had provided us with a discharge summary from the visit from the hospital in Florida that they had just left, which is somehow how we got some of the specific dates of the history.
Understood. And so rather than go line by line here, can you just describe in summary form what this HPI is discussing and explaining?
It's accounting for multiple visits to healthcare for respiratory illnesses that were thought to be asthma, and so treated with multiple courses of corticosteroids, and then was thought to have a complication from those corticosteroids during her last admission to the hospital.
And what are corticosteroids?
They're a type of medication used to decrease inflammation.
Okay. And I see references to myopathy and suspected myositis. What are those?
So myopathy and myositis would be a complication of corticosteroid use in some patients.
Okay. And possible neuropathy and pain. What is that?
Neuropathy and pain would be just sort of irritation of the nerves or any kind of pathology of the nerves that causes pain. Typically, any sort of injury or inflammation can cause sort of that finding.
Okay, and I think your note also references that the patient at some point became unable to walk. Do you see that? It's under
Yes.
7/4/2014.
Yep.
Okay. Was that something that was also communicated to you by either the patient or the mother?
Yes.
Based on your note here, what is your understanding of some of the hospital course at Johns Hopkins All Children's Hospital prior to transfer to Lurie Children's?
She was admitted there, and they diagnosed her with adrenal insufficiency, which is a complication you can get from chronic corticosteroid use. And they tried to treat her pain with multiple medications, including Toradol or Ketorolac, morphine, Valium, and IV Tylenol or acetaminophen.
Okay. And I understand it looks like there was also a neurology consult done there. You see that in your note?
Yes.
Okay. And it appears as if there was also pain management services that were consulted at Johns Hopkins as well. Is that correct?
Correct.
Okay. And the very bottom of your note, 7/2015, it indicates that mom requested discharge from St. Petersburg and mom arranged transport to Chicago. Do you see that? Oh, yeah. Of course. There it is. Okay. And so is that your understanding of how the patient came to be treated at Lurie Children's?
That's correct.
Okay. And under medications here, it lists several medications, some of which say last given and some of which don't. Can you explain to me the difference between a last given medication and a medication that's just listed?
The medications listed without any last given behind them are more for respiratory complaints or concerns about allergic kind of complaints, whereas the ones with last given are all pain medications, which would be much more sensitive to timing. So they were documented as to when she got her last dose, so you could make sure they didn't miss doses of her medications when she was presenting with pain. Those rather.
Okay, let's go ahead and we'll move over to 136 here. Past medical history. What did you indicate there as to the patient's past medical history?
We had no specific medical history on file from our records.
Okay. And same question for those medications that were listed back on LCH 136. Would that have been something you would have confirmed or something that would have been per patient or parental report?
Per patient or parental report.
And what was your understanding of the patient's constitutional situation under review of systems as of July 21, 2015?
So she reported pain and weakness for the last 15 days and a recent diagnosis of the steroid-induced myopathy or myositis.
Okay. With possible neuropathy/pain?
Correct.
And was that your understanding under constitutional? Was that your understanding of that was the purpose of this hospitalization, was a workup for these issues?
Correct.
What is a physical exam?
When the patient is in the emergency department, we'll assess their physical state of being objectively and document that in this portion of the note.
And do you do that with a hands-on assessment?
Correct.
And in this case, did you perform the hands-on assessment for Maya Kowalski?
I did.
Okay. And I also there looks like there's some vitals listed there as well. What are vital signs?
So they're measurements of kind of the patient's overall well-being, again, measuring pulse, blood pressure, temperature, respirations, weight, and pulse oximetry.
Okay. In terms of the patient's pulse, what was listed?
75 beats per minute.
And is that something that's within normal range for a pediatric patient of Maya Kowalski's age?
It is.
How would you characterize a pulse rate of 75 for a pediatric female who's 9 years old?
That'd be within the normal range for that vital sign.
Same question for the blood pressure here of 114/65.
That would be within the normal range for that vital sign.
Okay. Same question for temperature, respiratory rate, weight, and SpO2.
For the temperature, respiratory rate, and SpO2, those would all be normal. I would want to confirm it with a growth chart as to the weight, as that's normal for her age.
Thank you. And you note here under general appearance, alert, active, responsive, well hydrated, well appearing. What does that mean?
She was awake and responsive to questions and answers. Didn't appear to be dehydrated, so there's no physical exam findings of dehydration, and overall no signs of distress at the time of our assessment.
Okay. And then what did you put here under lungs and chest?
Just to clarify, this is the nurse practitioner's note from the visit. I did do my own assessment down below, but she documented clear auscultation, meaning there's no abnormal sounds when you listen to her lungs with the stethoscope. and she was in no distress.
Okay. Do you see any, based on your review of Exhibit 1, do you see any evidence of a patient suffering from an asthma attack or some type of asthmatic episode?
Not that, no.
I'd like to now go down to skin normal. What does that mean when you document on a physical exam, or your nurse practitioner documents on a physical exam normal for skin?
We don't identify any abnormal findings such as rashes or any other changes to the skin on the examination.
Is it your ordinary practice or the ordinary practice of your providers that you work with that if they notice a lesion or something like that, or a rash, is that something that would make its way into a physical exam finding?
That's correct.
Can you read under neurologic what your APRN noted as a result of the physical exam that was performed?
The patient was unable to cooperate with the examination to be able to obtain reflexes. Patient with good upper and lower strength, parentheses, as demonstrated by kicking this provider with both legs, pushing herself up and into her mother's arms with her arms.
Okay. And now, recognizing that some of the jurors that may hear this testimony are not physicians, can you kind of explain in lay terms what this neurologic physical exam note is describing?
That it was difficult to complete the physical examination secondary to her cooperation with our requests for different maneuvers that we would do to test her strength and other neurologic functions. But based on the behavior she exhibited with her kicking our nurse practitioner, as well as pushing herself up using her arms and her bed, that she appeared to have normal strength for those maneuvers.
So why is it significant that the physical exam notes that the patient was able to kick a provider with both legs?
The concern being that she had weakness, it would demonstrate that there was some more strength than we were able to assess by her cooperating with us on exam. And so we felt there was some strength that was present, even though she denied being able to move her legs otherwise.
Okay. And I'll ask the same question here for the statement here, pushing herself up and into her mother's arms with her arms. Why was that entered into the note, and what is the significance of that entry?
It would show that she had a fair amount of strength in her arms to be able to lift her own body weight, which was not what she was demonstrating to us on our examination. We asked her to demonstrate her strength otherwise.
If you could just describe to me what the assessment and plan is on LCH 138 here as indicated by your nurse practitioner.
So it says that she has a percentage of generalized weakness and generalized muscular pain, with symptoms that were ongoing for a while at this point in time. So we were concerned for possible myopathy and myositis has been the concern at the other hospital. But there's also concern for conversion disorder at that point in time initially. So we were going to do some laboratory testing to try to confirm that any objective findings consistent with the myopathy or myositis, and go from there once we get the lab results back.
Okay, and then there's a reference here to conversion disorder being on the differential. What is conversion disorder?
It's a psychiatric condition where patients demonstrate physical findings that are not necessarily physiologically derived or not necessarily pathologically derived, and often is a manifestation of a psychiatric diagnosis.
Okay, and what does it mean that conversion is on the differential?
It was on our consideration as possibly playing a role in the patient's presentation, but not necessarily confirmed at any point in time.
Okay, and is that why you did a med psych consult for this admission?
We didn't do one in the emergency department. I think they did one after she was admitted, but we thought it was an appropriate part of the medical care to be provided. Yes, based on the labs they had sent, which was a complete blood count as well as a complete metabolic panel, and a CK, which is a muscle enzyme that is detectable after muscle breakdown. They all appeared to be reassuring at that point in time from the previous hospitalization.
So what does that mean, the CK was reassuring?
That it was likely within the normal range of the lab value or slightly elevated, but not to the market amount we would expect it to be elevated if she was having significant muscle breakdown.
And what is the significance of muscle breakdown in terms of this patient's presenting suspected diagnoses?
We would expect if there's significant myositis that there would be some sort of CK elevation associated with that.
Okay. And so the fact that CK was reassuring, what does that mean?
It made us less concerned that there was a myositis picture going on as the cause of her weakness.
Okay, can you walk me through each one of those items and tell me what those are and why that was on the plan moving forward for Maya Kowalski?
Yes, so this is our plan at the time of our first assessment of her. So the PIV would stand for peripheral intravenous line. So establishing IV for medications and fluids if need to be given, as well as to do a laboratory draw. CBC would be a complete blood count, which is a lab test we were going to obtain, as well as a complete metabolic panel, which is CMP. CK is the muscle enzyme we discussed just a moment ago. Morphine was indicative of, we were planning to give her a dose of morphine because her pain control didn't seem to be adequate at that point in time. Tylenol as well for pain control. And then we figured it on our first assessment that she would likely need to be admitted to the hospital to general medical service for pain management as well as other further evaluation. And then a med site consult would be helpful to determine if this may be related to a psychiatric diagnosis or not.
All right, and this my understanding is on 138, this was entered in by your APRN or your nurse practitioner, is that correct?
Correct.
Okay, so when we turn to the next page, and I think that APN is Janice Zinani, is that correct?
That's correct.
Okay, and you worked, and back at this time, did you work with Miss Zinani?
I did, yeah, I do still, yes.
Why don't you walk me through the process of how an APRN does an assessment and then how you got involved in this case in terms of your assessment and entering a note about your assessment?
So once the patient is seen by our nurse practitioner, she would come in and present her findings to me. And then after we had come up with a plan together, I would go examine the patient and get a history independent of her to confirm the findings and see if I detect any other new findings, and then document that in my portion of the note, which is displayed here.
And so why don't we walk through the second paragraph here of your note. Do you see there where there's a reference to prolonged recent hospitalization with presumed diagnosis of steroid-induced myopathy, which has made her non-ambulatory and bedbound for the last 3 weeks at All Children's in St. Petersburg, Florida? Do you see that?
I do.
Okay, what are you describing there in your note?
That she'd been on this corticosteroid regimen, and there's concern for myopathy from the previous hospital, where she had been not able to walk in her bed for the last 3 weeks prior to coming to our hospital.
I'd like to move down here to the second paragraph. You see where it says, actually the third paragraph, where it says mother specifically requesting further diagnostic workup. You see that?
Yes.
What does that mean?
The mother had relayed concerns about the accuracy of the diagnosis and was wanting further evaluation in our hospital to make sure that we were on the right diagnosis and no other complicating factors would be present.
You indicate here in your physical examination, quote, exam limited by patient screaming and mother requesting no further examination after light touch to dorsum of foot induced intense pain. Do you see that?
Correct.
What are you describing there in your physical examination?
I had touched the top of her foot lightly with my hand, and it seemed to induce severe pain in her that she began screaming afterwards. So the mother had requested that we didn't do any further physical exam at that point in time.
Okay. And the next line, you say patient is awake and alert, near constant screaming and pain, but distractible easily and will answer questions, hold conversation without apparent distress, and quickly go back to moaning and screams. Do you see that?
I do.
What are you describing there in your physical examination note?
If I would ask the patient questions or hold a conversation with her, she didn't seem to have any ongoing pain during that period of conversation. Once the conversation ended or she was done responding to my questions, she quickly would go back to sort of moaning and screaming in pain.
Okay, and as a pediatric emergency room physician, why is that significant, if at all?
Distractible pain is often considered to be less severe than non-distractible pain. It means the mind can be fixed on other things besides just the pain itself.
Okay. Is that something that you would potentially lead you to conclude that conversion disorder should be put on the differential?
Not necessarily, no.
The term distractible appears in your medical chart, does it not, doctor?
It does.
Can you just explain what that term means in the context of a workup in a pediatric emergency room?
Whatever behavior the patient would be demonstrating at that point in time can be stopped by giving the patient some sort of other stimulus that would distract them away from whatever the behavior was for a period of time.
And then here you note, quote, lung without observed decreased aeration, but limited as constant screaming with assessment and auscultation triggered coughing spell, but no cough prior. What are you describing in that portion of your physical examination?
The listening to her lungs with a stethoscope was somewhat limited because she was screaming constantly, so I couldn't get a good listen to whether or not there was any wheezing or other abnormal findings present. But with the deep breath that she took for the examination, she did start having a coughing episode, but had not been coughing prior to that deep breath that she took during me trying to listen to her lungs.
And why is that a significant finding that makes its way into this emergency medical chart?
Since it was a limited ability to listen to her lungs, the lack of cough prior to that indicated that she was in significant respiratory distress to me.
So when you're saying no cough prior, are you saying Mike Kowalski was not demonstrating a cough until you started doing deep breathing to try to listen to her lungs?
Yes, that's correct.
Are you familiar with the term psychogenic or habit cough?
I am.
Well, what do those mean?
Typically, they mean a cough that's not triggered by respiratory illness, but more through a psychiatric condition.
And then when you listen, you detected, I believe, 75 beats per minute of the heart. Is that correct?
I believe, yes, that's correct.
And then to finish off this paragraph, you document skin pale but no rash. Do you see that?
I do.
What are you describing in that entry?
That she appeared pale and slightly less pain. Because when you see paleness, just indicates a possible finding of anemia or other sort of illness. But there's no rashes or specific localized changes to the skin that we identified.
If you had seen some localized changes in the skin, is that the kind of thing that would make its way into your attending note?
It would.
And what, if you could just describe in general terms after reviewing assessment plan, what was your assessment and then plan for this patient moving forward?
So we were in agreement that there could be possible steroid-induced myositis, as to what the other hospital had been concerned about. Although we felt that the pain was more diffuse and profound than you'd expect to see in just straightforward myositis. And some of her behaviors that indicated she was in rather severe pain were a little bit atypical for what we typically see in a patient who's on that aggressive of a pain management plan that she had presented with.
Okay. What do you mean by atypical?
Not the standard findings you expect to see in the majority of patients.
Okay. And I see here in your note, you say, although pain is more diffuse and profound in her behaviors than would anticipate with this aggressive pain management, and labs do not show signs of muscle injury with normal CK. Do you see that?
I do.
Can you break down in layperson's terms what you're describing in that portion of your note?
That she was on a significant amount of pain medications when she presented, but she still had profound pain that had not been responsive to the pain medications they had used thus far, which would be a little atypical, and that her labs at the time of our assessment showed no signs of muscle injury based on the laboratory findings of the CK.
Okay. And then you note here, quote, her behaviors are concerning for psychiatric component of the pain, possible conversion disorder with the distractible nature of her pain. Do you see that?
I do.
What are you describing in that portion of your note?
That her behavior during the examination was concerning for at least some component of her pain being related to an underlying psychiatric or psychological disorder.
Okay. And so did you have an idea exactly what that psychiatric disorder was at the time, or are you just saying it's a possibility that needs to be addressed further?
Just it's a possibility that needs to be addressed further during the hospital admission.
Okay. What specific behaviors were concerning for a psychiatric component that you observed?
I'm not sure exactly based on my note. I don't recall the visit independently.
Okay. So just based on your note, what were some of the behaviors that were concerning for a psychiatric component?
I would say that the distractible nature of her pain behavior, as well as the lack of cooperation with the examination.
Okay. And again, we talked about conversion disorder. Based on your reading of this note, why was conversion disorder on the assessment plan?
I think her lack of response to appropriate treatments thus far, an atypical presentation of what the the diagnosis she had been given at the previous hospital would both be concerning for that condition.
I see here at the very end of your note that you did an admission to Gen Med. What is that?
It's our general medical service, so the service that takes the majority of our patients with complex issues or issues that can be dealt with by a straightforward non-specialist group.
And what specialists, what team of specialists did you think would be needed to be consulted here for Mike Kowalski at Lurie Children's?
I thought likely the psychology or psychiatry department would have to be involved, as well as the pain management team.
Okay, and so why did you decide to get the psychology team involved?
I think it's the concern for a possible psychiatric disorder complicating her presentation.
Okay, and then why did you get the pain team involved?
Her pain management didn't seem to be adequately controlling her pain at the time of presentation, and so in an effort to try to improve her pain, thought that they could add other expertise in that area.
What is the Rehab Institute of Chicago?
It's a hospital that specializes in rehabilitation of patients who've had injuries or other conditions that make less able to do their daily routine and activities of daily living.
Okay.
Affiliated with our hospital.
Oh, so it is affiliated with Lurie Children's?
We're all under the same scope of Northwestern University.
Let me ask you just some general questions about ketamine. Does Lurie Children's Emergency Room have any type of protocol for the administration of ketamine to patients?
Yes.
Okay. Do you have a reference range in terms of in terms of milligram per kilogram per hour? What type of doses that you guys administer there at Lurie Children's with respect to ketamine?
In the emergency department, we don't use a continuous infusion. We just do bolus dosing of ketamine for procedural sedation.
Okay, and why don't you do continuous infusions?
It's not something that many of our providers have been trained on, and our nurses are not trained on it either.
If you're going to have a continuous infusion at Lurie Children's, what wing of the hospital would a patient need to go to?
Like the ICU, or intensive care unit.
The intensive care unit? Okay. And why is that?
It requires close monitoring of nursing that needs to be typically one-on-one or very near that nursing staffing ratio, and then you need to have very close attention from the providers administering the medication as well.
In terms of bolus doses for ketamine, do you guys have any guidelines at Lurie's regarding the types of bolus doses of ketamine that you will administer in the emergency room?
I believe our maximum dose is 2 milligrams per kilogram.
Have you ever heard of a patient or a patient's parent coming into your emergency room at Lurie Children's and asking for 1,500 milligrams of ketamine? What was that? What was your answer, sir?
I don't recall any cases of that high.
That's a max dose, so you could give less than that, but you're not going to give more than 2 milligrams per kilogram. Is that correct?
That's correct.
Why is it, doctor, that at the emergency room at Lurie Children's Hospital, you don't administer more than 2 milligrams per kilogram of ketamine as a bolus dose?
I believe that anything higher than that would be out of the recommended dosing range from the manufacturer, but also there'd be safety concerns about the tolerability of that high dose.
Okay. All right. Do you use propofol to sedate patients in the emergency room?
I do not know.
Okay. What about intrathecal clonidine pumps? That's something that your service recommends for chronic pain patients?
We do not do that, no.
Am I approaching, saying that correctly?
That's correct, yes.
I did not see anywhere in Exhibit 1, which begins at 0135, that being the Lurie Hospital records. I did not see a notation anywhere that the mom was acting in any unusual or concerning manner. Do you?
I do not see that, no.
And given a background in spotting child abuse, if a parent was acting in an abnormal or unusual manner in relation to the care and treatment of their child, that would be something that would be incorporated into the record, would it not?
It depends a lot on the presentation. Sometimes we would include it, sometimes we would not want to include it, as that could be inflammatory to the patient down the road if that was not found in fact to be true.
Define conversion disorder for the jury.
Conversion disorder is presentation of a physical complaint or pathologic sort of disease state process that's not necessarily founded in the underlying pathophysiology and more based on patient's psychiatric or psychological condition.
And so it is a diagnosis of, in this instance, it would be a diagnosis, if it were true, of the child, not of the mother, correct?
Correct.
Do you understand what happened in this case generally?
I am not aware of anything outside of the ER visit with the patient.
Okay. You're nothing in your, strike it. Although it's called by a different name right now, are you aware of a condition formerly known as Munchausen by proxy and now known as factitious disorder by proxy, or a term similar?
I'm aware of that condition, yes.
I didn't see anywhere in these records where you made any such diagnosis. Is that true?
I did not make that diagnosis, no.
Nor did you recommend over for a psychological or psychiatric evaluation, Maya, with any indication that that was a concern, correct?
That was not indicative of that, no.
And did you have the opportunity to review any of the records, prior records of Maya? That is, from prior hospitalizations, prior treatments, things of that nature.
I did not know.
Have you treated children with complex regional pain syndrome, previously known, some people still do, as reflex sympathetic dystrophy?
I have, yes.
I'm not asking you for a definitive diagnosis, but insofar as her extreme reactions to imminent belief of pain or touching, in your experience, could this be an indicator of complex regional pain syndrome?
Complex regional pain syndrome is not a diagnosis I typically make, so I would defer to the specialists in that area.
What is a hyperesthesia?
Hyperesthesia would be an increased sensitivity to different sort of stimulation in the area of the body that's referring to.
Well, how can you say a neck is supple if you haven't had a chance to touch it?
So she's actively ranging her neck through the full range of motion. That would be indicative of a neck that is supple.
Isn't it true, doctor, that there were certain areas, such as the top of the feet, where if you touched her, she would scream in pain? In other areas, if you brushed up against them, lightly touched them, she did not.
Again, I don't recall anything beyond what's documented in the note, but definitely had intense pain with the touching of the light touch to the dorsum of the foot.
Statement here, patient kicking this provider with both legs and pushing herself up and into her mother's arms with her arms. You would agree that this is somewhat unusual behavior, is it not?
That would be atypical behavior for that age patient, yes.
Right. But it's not atypical behavior at all for a child with complex regional pain syndrome, is it?
I would defer to specialists regarding that.
You note that on several instances that she could be distractible from her pain. Is that not also an indication of CRPS?
Again, I would defer to the specialist regarding the specifics about the diagnosis.
Did you use any of the following examination tools in examining Maya? A pin to test skin sensitivity?
I don't see any documentation of that, no.
All right. Temperature tape.
Sorry, what was that?
Temperature tape or an infrared thermometer.
We did take a temperature. I'm not sure of the measurement device they used for that, though.
Okay. Was the temperature simple, normal bodily temperature, or was there any attempt to check temperature in different portions of Maya's body? Extremities, abdomen, things like that.
We would typically only check it in one portion of the body.
Okay. Was there a von Frey test? Or Frey test?
I don't believe so.
Was there a weighted pin test?
Again, I'm not familiar with what that test is.
An algometer. Was that used?
I'm not familiar with that testing device either.
Goniometer. Was that used?
Again, I'm not familiar with that testing device.
Skin. Have you ever seen photographs of what CRPS lesions look like?
I can't say that I have, no.
Okay. And do you know whether they appear in parts of the body that are sometimes difficult to see with a basic examination? Under the armpit, the back of the forearms, things like that.
I'm aware that sometimes those kind of lesions are difficult to detect on physical examination.
And so I take it that you continued with the diagnosis of myopathy and myositis and possible neuropathy pain that she entered with?
We could not rule. We had no evidence against those diagnoses, so we presume they were accurate in our evaluation of the patient.
And did it come to your attention that this was these diagnoses came from Johns Hopkins All Children's Hospital in Florida?
That was our assumption, yes.
Can we pause for a second?
Do we need to pause?
Yes. I didn't hear any audio.
Oh, I think there's just a pause before the question, Judge.
Okay. He's really good at sitting still.
Regarding ketamine, you yourself are not an anesthesiologist, as I understand your training?
I'm not an anesthesiologist, no.
And I gather you have not been involved in the actual treatment of patients with CRPS?
I have not, no.
Finally, were any other tests such as MRIs, nerve conduction studies, EEGs, EKGs, anything like that done towards a diagnosis with Maya?
Not during the time in the emergency department, no.
I think you testified in response to Mr. Anderson's questioning that you do have some experience with complex regional pain syndrome. Did I hear that correctly?
I've treated a handful of patients that have come in with that diagnosis, yes.
Have there been occasions in the past, doctor, where you've placed CRPS on the differential diagnosis for a pediatric patient?
Yes.
And was complex regional pain syndrome on your differential diagnosis for Maya Kowalski?
It was not.
Why not?
The diffuseness of her pain involving almost her entire body would be typical for complex regional pain syndrome.
Can you name for me the 5 different symptoms that you would look for in a differential diagnosis of CRPS?
I would defer to the specialists in different, other than my specialty, regarding what the findings are that are needed for the diagnosis.
Yes. What are, out of the 5 sample signs, can you give me one of the sample signs for a differential diagnosis of CRPS?
I'm not familiar with the term sample signs regarding chronic regional pain syndrome, no.
Suffice it to say you are not an expert in CRPS. Agreed?
That is correct.
You agreed that you would defer to those physicians who have studied CRPS for a lifetime?
I would defer to them, yes.
Well, if you had considered it, you would have put down the basic categories and whether any of the sample systems were present, would you not?
I would say we consider numerous diagnoses from every patient. We don't always document all the things we consider in their evaluation.
Okay,
That would
that's,
conclude the deposition.
okay, members of the jury, we're going to take a 5-minute break. Let's try to keep it to 5 minutes. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. I can see. Received a note from the juror wanting to clarify the November 9th because employers are asking, can you clarify the November 9th date? Is this when you expect attorneys to be finished and then the jury deliberate, or does November 9 include jury deliberations? And it also says, thank you for the decorations, made us all laugh. One of the jurors has a birthday over the weekend, so my assistant put a happy birthday sign up, and then for the 11 others, we put a happy unbirthday sign up. So, I was going to clarify when they come back that November 9 would include deliberations.
Agreed.
Anything else before we take 5 minutes?
No, you're.
No, no, okay.
Okay, let's take 5 minutes.
All rise. Scores in recess.
concern with telling the jury that deliberations will be done by the 9th is, we hope they'll be done by the 9th with this jury. I just anticipated that it will include.
What I will say is, my goal is to get this,
I'm done.
Yeah, we want them done.
Sorry. Yeah, sorry, Your Honor.
get this to you to begin your deliberations by, I really want to do it by the 7th.
Okay.
Yeah.
And then I can say, and it'll be up to the jury to determine how long it wishes to deliberate.
Yes.
Is that fair?
Yes.
Fair enough, Judge.
Anything else before I bring in the jury?
Not for the plaintiffs.
Let's bring in the jury, please. Okay. Everyone.
Members of the jury, I just want to confirm while you were away, you did not discuss this case amongst yourselves. You did no investigation, you received no information. Is that all correct? Correct. And has anyone approached you about this case since you were last with us? No. And have you seen any media coverage concerning this case since you've last? No. Okay. There was a question about the November 9th end of the trial, and whether that's the time that you're going to begin to deliberate, or would that include the deliberation dates? I anticipate, and I think that you will be able to begin deliberations on November 7th. So once the jury begins to deliberate, it becomes really in the hands of the jury as to how long you deliberate. So my goal is to land this case for your deliberations November 7th. If that is going to become difficult or impossible, I will let you know when I know it. But as of right now, I continue to believe I can land this by November 7th. So, okay. With that, defense, your next witness, please.
We call Detective Stephanie Graham.
Testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
All right, gotta come this way. I'll have a seat for this thing.
Okay.
May it please the court. Good morning and happy Friday.
Good morning.
Okay. Would you introduce yourself to the jury, please?
Hi, I'm Stephanie Graham.
Okay. Ms. Graham, will you give this jury the benefit of your background and education? Well, let me just set the table first. We're going to talk to you about some involvement in this case, in the Kowalski case, in October, November of 2016. Okay.
Yes.
Can you tell the jury what was your occupation at that time?
I was a detective with the Sarasota County Sheriff's Office.
Okay. Now we're going to work backwards. Okay. Can you tell the jury, starting with college, where did you go to school?
I graduated from University of South Florida with a Bachelor in Arts in Criminology. From there, I went to the Sarasota Criminal Justice Academy, where I graduated first in my class in 1998 and subsequently was hired by the Sarasota County Sheriff's Office.
Okay. Did you go to the Sarasota County Sheriff's Office right out of, I think you said it was a detective school or officer school? Criminal Justice.
Criminal Justice Academy. Within about a couple weeks, my hiring process, I believe, had started prior to my graduation from the academy. And then I was hired April 30th of 1998 because I just retired this past May.
So we're bringing you back. We're going to put you through a little memory contest. But so once you finished the academy and you have the job at the sheriff's office and that time period, what did you do for the first years? What types of roles?
Okay, so during my 25 years with the Sarasota County Sheriff's Office, I had the privilege of working in several different areas. One being a court deputy. I worked as a patrol deputy, a criminal investigations detective, a special investigations detective, a special victims unit detective, and a civil unit deputy.
Okay. Was there a time that you became assigned to what the jury may know of as sort of special victims or vulnerable victims units?
Yes, I became a member of the special victims unit, I believe, in June of 2012. That unit is responsible for investigating crimes involving child victims that might be child abuse, neglect, also vulnerable adults such as disabled or elderly adults. Those individuals in our community who are most vulnerable.
Were you in that role in October and November of 2016?
I was.
Okay. And I understand that you recently retired?
I did in May of this year.
Okay, congratulations.
Thank you.
So let me ask you a little bit about your involvement in the Kowalski case. Okay. How does, and maybe I can just sort of streamline this. When a call is made to the abuse and neglect hotline, is there a track that involves law enforcement?
Yes, generally
Objection,
there.
Chapter 39.
Yep.
Mr. Shapiro asked the question.
Okay. Let me just try to streamline this so we can get to the reason we called you. Once the call is made, the law. If I understand what your testimony would be, the law enforcement angle of this would get assigned from your sergeant to you. Is that right?
Yes, generally my sergeant would assign the cases that came in through DCF to investigators within our unit.
Okay. And then the reason why you decided you wanted to meet with Jack Kowalski would be in pursuant of that investigation. Is that right?
Yes.
Okay. There was a date, and I'll reference to you that it was November 17th, 2016, that you had the opportunity to meet with Jack Kowalski. Is that right?
I don't remember the date specifically, but if that was noted, yes.
Okay. Why did you want to meet with Mr. Kowalski?
Well, at that point, I had been in contact with the Department of Children and Families about the progress of the
their case, and I was told that Jack.
Okay, I'll lead. Okay. Well, let me just lead you through there. You met with Jack Kowalski at All Children's Hospital.
I did.
Right? Okay. And you met with him in order to get his understanding of the situation that you were investigating. Is that true?
Yes.
Okay. And just to be clear, when you met with him, you're not affiliated with All Children's. You're meeting with him totally separate as a member of the Sarasota County Sheriff's Department. True?
Correct.
Okay. Where did you meet with him?
At All Children's Hospital, we were given a private room. I believe it was like a family waiting room where we had an opportunity to speak privately.
Okay. How are you attired when you met him?
Fairly the way I would be today, slacks, a blouse. I would be wearing a badge and my gun.
Okay. And how would you introduce yourself to Mr. Kowalski?
I would introduce myself then as Detective Graham with the Sarasota County Sheriff's Office.
Okay. Would you have given him your card?
Of course, if, as a general rule, either before or after, I would supply someone my card.
Okay. Did you tell Mr. Kowalski that his interview with you was completely voluntary?
I did.
Okay. And did he agree to sit down and talk with you?
Yes.
Do you remember approximately how long the conversation was?
I don't. I know that it was long. I don't have it was over an hour, well over an hour.
Did you tell him at least twice that he was free to leave the conversation at any time?
I know that later in the conversation I did tell him and reminded him that I'd already told him this was voluntary, the door was unlocked, he was free to leave if he wanted.
Okay. Did you record the conversation?
I did record the conversation.
Okay. And why do you record conversations?
Recording a conversation during an investigation is the most accurate way to determine what was said during an interview.
You've had a chance to listen to the audio.
Parts of it.
Right. Are you able to tell the jury whether your recorder was by phone, on the table? What's your best recollection of this?
My best recollection that it was likely my iPhone is what we would use, our work-issued phone.
And is that a phone that you would have put on the table, most likely? Do you know?
Probably. Pardon me.
Okay. Let me ask you about some of the conversation that you had with Mr. Kowalski. When you met with Mr. Kowalski, did he talk to you about any meetings that he had at the hospital regarding his consent for treatment there?
Yes, he did describe a conversation that had taken place where he had expressed his consent for the child to be treated.
Okay. Your Honor, I'd like to publish to the jury what's been previously marked into identification as Defense Exhibit 3121A.
Yes.
I mean, when we were in the meeting with the doctors one day, and the other one saying, Maya, I'll sign her out. And I said, hold on, time out. And if this wasn't in a, wasn't written down, which I was kind of mad about, but I asked the doctors, I said, what's the time frame you talking about? And they explained. I said, that's doable. And was my wife happy with what I said? No, absolutely not. So you have to, there's times I'm going to go the other way.
Okay. And thanks for sharing that.
I don't know why they didn't write that down.
Was this a theme of your conversation with Mr. Kowalski where he was expressing to you that he was supportive of having Maya treated at All Children's?
Yes, that did come up.
We're beyond this, leading on this stuff.
On that question, I sustain the
Do you recall during your conversations with Mr. Kowalski whether he made other statements to you regarding his either consent or lack of consent at keeping Maya at All Children's?
That's my recollection, but I might need to.
overall, you can answer that one.
That's my recollection, but I would probably need to refer to the transcript to know specifically what those statements were when they occurred in the conversation.
Okay. Your Honor, I'd like to publish into evidence, publish to the jury what's been previously marked as 3121B.
You may.
My bigger bigger question is, why would a parent go to these extremes?
Because I'm told this is the last resort.
But you're saying it's not. And this is not, I mean, also what would have taken was a question from you somewhere along the line that are we doing the right thing? Maybe we should go back and talk to another doctor, do something more conventional, not something that's likely to kill her.
I'm effective of keeping her here. That's what I told you. And if they think something else, I'm supportive of keeping her here and looking.
Detective Graham, having heard that audio, does that refresh your recollection as to the conversation that you were having with Mr. Kowalski?
Yes, it does.
Was there a time during the conversation that you had with Mr. Kowalski where he indicated to you any concerns with Mrs. Kowalski's behavior?
Yes.
Okay, and what types of concerns was he expressing to you?
She wasn't being cooperative with the things that were being requested. He stated he was appalled by some of her behavior.
Your Honor, I'd like to publish to the jury what's in evidence as 3121C.
You may.
But it's just your wife's behavior is very concerning to me.
Sure. And it's getting worse right now. Just, she don't want to cooperate.
Along those lines, Detective Graham, did Mr. Kowalski discuss with you during this time that any concerns he had with Mrs. Kowalski following the rules?
He had expressed there had been some interference on her part with him trying to communicate with Maya, yes.
Okay. Your Honor, I would like to publish to the jury what's been received into evidence as 3121D.
D as in Delta, yes.
Because I know Mom talked to her once, and that was supervised. And I guess she got shut down many times because she was falling off the track.
She could.
And then she told me what she said. I said, you can't do that. Don't talk about medical stuff. Why are you talking about the lawyer? Why are you doing?
Why can't she control her? If her daughter is her main priority and why can't she follow the rules and do what she's being told?
Exactly.
During your conversation with Mr. Kowalski, do you remember any conversations with him about him noticing any differences in Maya's behavior, whether he was present or Mom was present?
Yes, he expressed that there were times he would be home alone and there would be no complaints of pain or discomfort, and when the mother would come home, the child would immediately be in pain.
Your Honor, I'd like to publish to the jury what's been received into evidence. One moment. As 3121I.
You may.
When nobody else was in the room but Maya and the staff, she acted completely normal. When Mom would walk in the room, she was instantly
I heard that many times.
There's no other explanation for that.
Yeah, I noticed it too with myself being home, and then Mom comes home from work.
And all of a sudden she's back.
So
you're at home, your guys are doing well, playing.
No complaints about me.
No complaints
but
about
then
that.
when Mom gets home,
She's
maybe-
okay.
During your conversation with Mr. Kowalski, did he express to you any of his intentions in terms of his home living situation with his wife if Maya were to come home?
Yes, he had offered to me that given the opportunity to bring Maya home, that he would have Beata move out.
If I could publish to the jury what's been received into evidence as 3121G.
You may.
I thought you were going to ask me the question if Maya was released from here and she was going to be brought back home, if I would have had my wife move out.
That's my next question.
That would be absolutely not our feet.
One moment, Your Thank you. I don't have any other questions this time, Your Honor.
I do have questions. There is a
Share terms with me.
there is a technique that, and were you a detective at this time?
I said I was, yes.
And how long after that were you a detective before you moved to another position?
I became a member of the civil unit, I believe, in November of 2017.
So what, about a month after this?
No, November of
Reporting?
2017.
About a year after this?
Yes.
You were no longer a detective?
No, I had chosen to leave that unit.
Okay. But at this point you were a detective. Now there's a technique that detectives use when they're trying to get a confession or something out of someone, and that's called flipping the accomplice. Is that not true?
I would assume so, yes. I've not heard that term referred to.
What do you refer to it as?
As doing an interview.
Well, it's a little more than an interview, is it not?
I'm not sure I understand your question.
Is it not for the purpose of getting one person that you perceive as part of the crime to testify against the other?
That can be, yes.
Right. And to do that, what you do usually is use threats of prosecution of the person you want to talk, right?
That could be possible, yes.
All right. So now, for instance, like here, like threatening Jack to let him know that you had put a father away for 10 years before, right?
I told him that, but I think that was out of context. It wasn't meant to be in that, the way you're referring to it as.
Just how far out of context can it be to tell someone in Jack Kowalski's position, with you there in that room with a badge and a gun, that you had put somebody else away for 10 years, impliedly for this?
My recollection of explaining that circumstance to him was that the parents thought they were doing the correct thing at the time they committed the crime and loved their child and had the outcome was not necessarily what they intended, but that there was a punishment for that. That is my recollection of the reasoning why I brought that case up.
You were reminding him that even though he loved his child, he was doing the right thing, he might in fact end up spending 10 years behind bars. That was the purpose.
I was explaining to him that even a loving parent thinking they're doing the right thing, not knowing what the end result could be punished for their actions, yes.
I noticed that you used a couple times the phrase, the opportunity to, as in the opportunity to meet. Do you recall that? Your testimony right here in front of the jury just a couple minutes ago.
If you're saying that's what I said, I don't remember using those exact words, but
Right,
if you're saying, that's fine.
They're taking notes. And also the opportunity to speak privately, right?
Yes.
Okay. But that's not exactly the way it went down, is it?
Is that a question?
Okay. That wasn't the way it went down, was it?
I asked if we could speak privately. We were given a private room to sit down and speak.
You were given a private room because the hospital knew you were coming, obviously, right?
Your Honor, just to briefly approach on this issue.
Thank you, Judge. So, you had discussed coming over there before with Sally Smith, had you not?
I don't recall talking to I don't recall talking to Sally Smith specifically about coming to the hospital.
Was she or was she not the main source of your information about this?
Your Honor, I'm okay if he wants to go there, but it's...
That question you can ask, but
Dr. Sally Smith was the main source for the medical information I was receiving. The custody and DCF side and family court side was through the Department of Children and Families and supervised visitation.
Right. So now, relying heavily on Sally Smith's information, you went to the hospital, and who did you meet there?
Just to clarify, the information I received from DCF and Sally Smith was why I went to the hospital. I probably had contacted someone with the hospital to facilitate getting us a room where we could speak privately.
Okay. And then Kathy Beatty met you at some point from the time you came into the lobby to the time you got on the elevator to go up to the PICU, correct?
That's my recollection, is that she's the one who facilitated getting the room.
All right. So you and Miss Beatty rode up in the elevator, right?
I would assume so, yeah.
Yeah. And were you in uniform at that time? No, you were plain clothes.
Plain clothes.
But you did have your badge displayed?
I did.
And you had a gun?
Likely,
displayed.
yes.
What kind of gun? A Glock? What was it?
6-hour.
A 6-hour. Okay. And so when the doors opened, were Jack and Maya standing there?
I
as
don't
you came
specifically
off?
recall that.
Mm-hmm. And in fact, the first time then, whether they were standing right there or close there too, the first time that they saw you would be with Miss Beatty, correct?
That's possible.
Mm-hmm. All right. And you got some information about this situation from Miss Beatty too, not you?
I had been in contact with Ms. Beatty as again, facilitating some information about.
And you've worked with Miss Smith, Sally Smith, Dr. Smith, excuse me, previous. with Miss Beatty. When we left off, you were getting off the elevator with Miss Beatty, were you not?
That sounds reasonable, yes.
Yeah. And then the hospital or someone provided a room for you. Is that right?
Yes.
And you sat down on one side of a table, a relatively small table, was it not?
I don't recall, but there was a table, yes.
Like it wasn't a gigantic conference room table. This was,
No. My recollection is like a small family waiting room.
Okay, small family waiting.
Or not small, but, you know.
And were you positioned such that Jack went in first and then you sat down between Mr. Kowalski and the door?
I don't recall where I sat specifically.
Okay. Then, you had a badge and a gun sitting with Mr. Kowalski in a visitor room, right?
Yes.
And you told him you were going to ask him some questions, did you not?
I asked if we could talk, yes.
And one thing you did not say at the start was, oh, and I'm going to be recording you.
No, I did not.
And in fact, your phone that you recorded it on was on your purse, kind of half in and half out of your purse sitting next to you?
Generally, if I've done hundreds of recorded interviews, it is either on the table and sometimes, yes, it might be in my bag. That specific day, based on the recording's clarity, I had reason to believe that it was on the table.
Okay. And so, Jack Kowalski, for the most of this conversation, did not know you were recording him.
He didn't. The recording states that there was some conversation prior to the recording starting. I don't recall telling him, but there is no right to privacy when you're talking to the police. I can record conversations as part of any criminal investigation.
Well, you knew he was represented by counsel, did you not?
I was not aware he was represented in any criminal matter.
Well, you knew he was being represented in the matter involving his daughter there at Johns Hopkins, did you not?
He talked about being represented. We actually discussed his attorney. He never specified that he wanted to speak to his attorney, but that was the attorney representing him in family court.
Did you ever then tell him he had the right to counsel at that point?
I'm not required to.
I see. Because you don't believe you had him in custody yet?
I know I did not have him in custody.
And at that point, you hadn't even found a reasonable suspicion. Is that right?
I had a DCF report. I had a medical staff with child protection team voicing concerns about the health and well-being of this child, with the concerns focused on the mother and her inappropriate behavior. And yes, I did have a reasonable suspicion to go and speak to him to find out what his opinion or basis was in this matter. That's what an investigation entails.
Well, would it be true that you at this point were not comfortable saying there's hang on one second. One moment, Judge, I need to find this. I'm going to need to come back to that. Are you saying then that a reasonable citizen, under these circumstances, with a detective, with a gun and a badge, sitting across from him, that he wouldn't feel just a little bit intimidated?
Sustained.
And in asking your questions, you used what we term leading questions, did you not?
I did ask him some leading questions, but he was very forthcoming with offering his own information that I did not ask for.
And your voice that we heard here was fairly aggressive about challenging him, is that right?
There was probably a point later in the conversation where I started to pressure him a little more as far as why this was occurring. I was questioning as far as why wasn't he asking more questions? Yes.
The point was, for virtually every single one of those recordings, you suggested or told him the answer to the question you wanted.
That is incorrect.
True?
I would disagree.
Did you not bring up in every one of those, isn't it true that? Or why didn't you do this?
You would have to refer to the entire recording, but that is not my recollection.
And so then, having done this, did you really expect Jack Kowalski to disagree with you?
During the interview, I told him right at the beginning, if he was not comfortable answering a question, he didn't have to. I explained to him that if I spoke anything incorrect, that he should correct me, and he did, and I thanked him for that. It was not a conversation that I was, just giving him question after question. We were having a conversation. I thanked him for sharing information with me. I explained to him that, my position, and then he would explain back what his position was.
Mm-hmm. And you did this, of course, before you went on record in the recording, did you not?
That would not be true.
You did not put it in the first part of the recording, did you?
The first part of the recording was maybe a few minutes. I went to double check to make sure. I'm sure there's nothing worse than doing an entire recorded interview and finding out your recorder didn't work or wasn't activated. So that.
Go ahead, sorry.
I'm sorry, but I refer later into the interview that I had told him he was there voluntarily, the door was unlocked, he was free to leave. That was expressed because I had told him that prior to the recording beginning.
Mm-hmm. So he just stayed there because he wanted to.
I've done hundreds of interviews of all different types of parties, and cooperation is not unusual.
And in this by a husband against a wife, that's been your experience?
I worked child abuse investigations for 5.5 years, and parents are always involved in these investigations.
Well, this is a little different investigation, was it not? This wasn't one where Maya Kowalski had bruises on her, was it?
No, this was a very complicated
right.
investigation.
And at that point, you had no evidence that Beata Kowalski had any psychological or psychiatric problems.
Mr. Anderson, why don't you all come forward?
As a general rule, we do not interview the child. That is for the child protection team to do.
And you never met Beata Kowalski?
I did not.
Witness.
For the jury's benefit, can you tell them whether you told Mr. Kowalski whether he was free to leave at any time?
I did.
Did you actually remind Mr. Kowalski that you were out of your jurisdiction?
Several times, yes.
And what does that mean to the jury when you're out of your jurisdiction?
I only have arrest powers within the jurisdiction of Sarasota County, and he was a fireman. They also deal with jurisdiction, so I think he probably understood that meaning.
You were asked some questions about whether you were leading him into answers. The jury heard one of the clips about Mr. Kowalski having his wife live out. Was that something that you asked, or did he volunteer that to you?
He volunteered that, amongst other information, yes.
At the end of the interview, do you recall if Mr. Kowalski actually gave you his cell phone number?
He did, and he also offered to let me come to his home if I wanted to talk to him further.
I have at this time we have
Mr. Anderson.
And if you decided to arrest, first, do you think Jack Kowalski understood exactly where your ability to arrest or not arrest was?
Speculation.
I told him I was out of my jurisdiction, and I believe I told him he was not under arrest.
That is not exactly my question. My question is, he would not know, unless he was a police officer or in law enforcement, where you could arrest or where you could not arrest. True?
Objection, speculation.
She's sustained on that one. She doesn't have to answer that.
And if Jack Kowalski was not there, something happened to him, and Beata Kowalski, something happened to her, the child would then go into what?
Objection,
That's not
sustained.
Nothing
further, Mr. Kerr?
No, thank you, Your Honor.
Members of the jury, are there any questions? Have you go to jury deliberation. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Arise, jury.
Jury's out of our presence. Detective Graham, if I could have you wait outside, please.
witnesses out of the room. Obviously, the jury's also out of the room. And so the plaintiff had on red number 1, an objection. That's the first question.
Yes, Your Honor.
Yeah, I do agree. The court can probably give an instruction.
question. I don't think anybody would object, because while you're away, you did not discuss this case amongst yourselves, you did no investigation, you did not receive any information about this case, is that correct?
That's correct.
And have anyone approached you about this case since you were gone? And have you seen any media coverage?
No.
And this witness was out of our presence when I spoke with the lawyers. And so, ma'am, I've got some questions from the jury for you. And just as a reminder, you will have all of what's actually in evidence with you, but you won't have what is not in evidence. Did you show Jack that you were carrying a gun?
It would be normal for me to be wearing my badge and my gun on a daily basis when I'm at work, yes.
The next part of that question, was he aware you had your gun with you?
It would have been holstered on my hip as part of my uniform that I wear every day during every investigation.
Do you remember if you gave Jack your business card before or after you met with him?
At the very beginning of the conversation, he requested my card and I offered it to him, and that was recorded.
When you say this conversation was voluntary, did you tell Jack there would be consequences if he did not speak to you?
No, I would not tell someone that. He was under no obligation whatsoever to talk to me.
If you were out of your jurisdiction, why were you interviewing him?
Because we were contacted by the DCF office in Sarasota County, and the family lived within Sarasota County jurisdiction, and that's why I was instructed and got involved. It would not be unusual for me to go to All Children's Hospital if the child was transported there and something had occurred in Sarasota County.
Did Jack inform you of his service? I assume that means of his fire department service.
He told me he was retired. I don't recall exactly retired from what, but he made a comment that he was a medic.
Did he demonstrate from that service that he possessed a knowledge of his rights as they pertain to your interview and his lack of requirement to participate?
There was no discussion about that.
I'm sorry.
I just want to say he appeared willing to converse with me.
Did he mention his legal counsel?
He mentioned hiring Deborah Salisbury, and that would have been part of the family court process, which is a separate process from my criminal investigation.
In your experiences, do leaders of, quote, police parallel services, end quote, paramedics/firefighters usually have more or less knowledge of their civic rights than average citizens?
I would not have an answer to that.
Did Jack demonstrate any non-verbal behaviors that made you feel the discussion was not wanted?
No.
Were you there to, quote, get
to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
Can I expound on that answer?
I think you should answer the question that was actually asked.
Could you repeat the question?
Were you there to, quote, get to an anticipated conclusion, end quote, or, quote, to seek the truth, end quote?
I was conducting an investigation to get to the truth and matter of the fact.
Did you inform Jack the reason for the interview?
I don't recall the exact verbiage, but I would have expressed there were some concerns. We'd received reports from Department of Children and Family, and I was following up those reports.
You said it was probably your iPhone that you recorded your interrogation of Jack. Where was your phone during the interrogation?
Like I said during my first the initial testimony, because of the clarity, it very well, I mean, it sounded clear. It was on the table. Obviously, I sounded louder in it. It might have been sitting next to me. But I don't have, right at this moment, that was many, many years ago, I don't have a clear recollection. That's would not be unusual for that to happen.
Was Jack given the notice the meeting was being recorded or to refuse the recording of the interrogation?
Well, it wasn't an interrogation, it was an interview. And no, there's no right to privacy when you're talking to the police, whether that's in the back of a patrol car, in a hospital, at their house. It would be common for me to record an investigatory interview.
In a yes/no, does the recording of the interrogation have a recorded opening with names, date, location, and consent to record?
It did not.
If not, then is it your usual modus operandi to record interrogations without the knowledge of the interviewee?
It would not be unusual to do that, no.
And members of the jury, those are the questions I'm going to be able to ask, and I cannot ask the other questions. Defense, is there any follow-up?
Just one. Detective Graham, why do you make the recording?
It is the most accurate account of what is being said for both myself and for the person I'm interviewing.
Thank you.
Any further follow-up?
I found the passage. Now I gotta put it together. I have to do something like this. Did you tell Jack Kowalski that you don't care, that you would put he and his wife in jail tomorrow if it means Maya gets better?
If you're saying that's what the quote is, then yes.
And did you remind him of what good it would do to Maya or Kyle if both their parents were put in jail?
Objection. Argumentative mistakes.
Overruled.
Could you repeat the question, please?
Did you tell them or ask Jack what good it would do if Maya or Kyle or if both their parents were put in jail?
I'd have to look at the, if you're telling me that was the transcript, but I'd have to see the transcript itself, yes.
You may approach.
Mr. Anderson, can you share with me what you shared with us?
Yes, this was at the very end of the conversation. I see where the quote is. Yes.
And so, what did you tell him?
Do you want me to read the blue highlighted area?
You don't have to read it, but let me just ask you again. You were telling Jack Kowalski you were giving him an opportunity because, and you ask him again, what good does it do if Maya or Kyle have both their parents put in jail?
That was what was said in the transcript. I forget what was the question. If you could go back.
You answered it.
I did. Okay.
Anything further?
Yes, briefly, Your Honor. Mr. Anderson showed you a page from what looks to be page 168 of the transcript.
Yes.
That conversation that he's referring to came after all of the statements that you and Jack had that we've published to this jury, correct?
Yes, I recall this was at the very end, and that I was expressing to him, because he had expressed me during this conversation that he was protective, he was encouraging, he was being the protective parent. And I was just expressing it doesn't do any good for both parents to be in jail. It doesn't do any good.
Well, let's explore that really briefly since you brought it up. Were those comments made as encouragement to Mr. Kowalski to be protective of Maya?
Yes, because that is what he had conveyed to me during the course of our entire interview.
And
that he would do anything, and even said he would go to jail tomorrow if he was responsible.
Right, and the comment you made was not about your desire to separate them. It was Mr. Kowalski telling you he's protective and that he wanted to have Maya home.
Yes, okay. That was his ultimate goal, was Maya.
At no time in your interview did you ever threaten to arrest him, did you?
No.
Okay.
Overruled. Can you answer that question?
You can answer.
No, in fact, at some point during the conversation, I think I said, you're not under arrest.
And you reiterated to Mr. Kowalski at least twice during the interview that he was not under arrest and he was free to leave. Is that
yes.
Correct? Thank you.
So you think it's encouraging to say, frankly, I don't care, I'll put you and your wife in jail tomorrow if it meant Maya gets better? That was encouraging to him. Is that right?
I was stating that my ultimate focus is the safety and well-being of the child. That is my goal as an investigator. And if that meant that I had to take action to protect the child from her parents, that is exactly what I would do.
Or it meant to let him know that if he had anything to add, he'd better add it right now, or you would consider taking him to jail, right?
I would disagree.
And didn't he say throughout he did not believe that Beata would ever harm her children?
I believe he said that he believed she would take the child back to get more dangerous treatments that we were trying to protect the child from.
That's not my question, ma'am.
Well, that told me that he believed that she might.
Ma'am,
pardon me.
Answer the question he asked and only the question he asked.
Yes, sir. Okay, could you repeat the question, please?
Didn't he tell you at least twice that he did not believe Beata would do anything to harm their children?
Yes.
Nothing further.
Members of the jury. Seeing none, may this witness speak. Oh. Okay, members of the jury. Let me try to do it real quick. And the question is, did you talk to him, being Jack Kowalski, again over the next few months?
No.
Members of the jury, that's the only question of this second round of questions that you submitted that I'm able to ask. So, is there any fault based on that one question?
No, Your Honor.
Okay, and may she be excused?
Yeah. Yes, sir.
Mr. Anderson?
Yes, Your Honor.
Okay. Ma'am, thank you very much. Members of the jury, given the time, I think it's a good time for us to break for lunch. Please do not discuss this case amongst yourselves. Do not do any investigation and receive no information about this case. We'll see you after lunch. Let's have them back ready to go at 1:30.
Jury exit.
Do you need to say it? Okay. Just hand it back to the clerk. Okay. Jury's out of our presence. Are there any issues we need to address before we go?
No, Your Honor.
Is 1:15 a time that everyone should be back?
Yes, Your Honor.
Can we ask what the afternoon lineup is?
Yeah, we're calling Ms. Masika at 1:30 for about 10 minutes, hopefully, and then it's depositions.
All right, well, we will request a proffer of Ms. Masika's testimony.
So have her
We can do
here.
that at 1:15.
Have her here at 1:15.
Oh, okay, I'll tell her.
Yeah, so we can do the proffer before the jury's supposed to be back.
Okay.
I'll see everybody back at 1:15.
All rise, goes in recess.